Alderman Bosley. Alderman French.
Present.
Thank you.
Alderman Vaquero.
Present.
Alderman Cone. Alderman Carter. Alderman Coter. Alderwoman Spencer.
Here.
Alderwoman Green.
Present.
Chairman Kennedy.
Here.
Alderman Coter. We have 5 present. And we have a quorum.
Thank you. We have several bills before the committee today. There is a sign-up sheet for anyone who wishes to testify in relationship to Board Bill, I believe it's 296. We have Board Bills 310, 296, 280, and then we also have a report today on the city's comprehensive crime prevention program. We will first take up Board Bill 310 from Alderman Ortman.
Thank you, Mr. Chairman, committee members. This, in my opinion, is a pretty simple bill. We at the city level don't have any legislation covering witness tampering. And it was actually brought to my attention, by the police and a city councilor that put it together. And what I did is I got that copy to our attorney, and they kind of worked it out off the state legislation and actually, I think, tweaked a little bit and got a better legislation moving forward. Basically, it's witness tampering. In the city of St. Louis, if there's an issue and somebody tries to do the right thing and be a witness, sometimes the accusers, or per se the bad guys, tell them you better not file a report, or you better not show up, or, and that is actually witness tampering. Now, you might say, well, we have the state legislation, but as far as, with the state, they've got to do, a total report and I guess get enough evidence for the state prosecutors to prosecute, which they're on overload anyway. So my opinion, a lot of times, what we could issue a summons are and get them in city court, and most of the time there's other than, the court, whatever issue, they're going to court, something causes the witness tampering. So there's, another issue there also. And the penalty would be $100 to $500. It would be a summons, and then up to the judge, and then or 90 days in jail, which is pretty standard for legislation that we have here.
Okay. Did you have anyone else you wanted to speak on this?
They had ComStat this morning, so they're supposed to be here, but they're probably running late. But it's fine. I don't know if you want to hold it and hear from the police when they do get here, or if we just, go ahead and pass it.
Let's see as we go through the question. Alderman French, any questions?
Yeah, we have some questions. So there is currently a state law against witness tampering, right?
Yes.
Okay. Is there an existing city law at all dealing
No.
with the subject? And the maximum penalty would be what?
The maximum penalty would be, according to our charter, $500, or up to 90 days in jail. But my guess is most of it would start out, unless somebody, is continuous, it'd start out at $100. That's normally what happens in city court.
Okay. And so the actual wording of this is that a person commits the offense of tampering with a witness or victim if, and I think it's two things they have to do. One, with the purpose to induce a witness or a prospective witness to disobey a subpoena or other legal process, absent himself or herself, avoid subpoena or other legal process, withhold evidence, information, or documents, or testify falsely. He or she threatens. Okay, so some of these things. So does this include attorneys?
I would imagine it would include everybody, I mean, we could refer to counsel on that, but,
I'm worried
you know,
if-
if you're
if-
tampering with a witness, that would be covered under, you know, this, you know, and if, or state legislation if there's enough of a case there.
I'd be interested in seeing how the state legislation is written, but,
We've
I
got
wouldn't want us to-
copies.
Would you?
We have copies here. Okay. Pass them on. Give you some more. Use one down there. I need one more. Thank you.
This is
Yeah, this is
the
just
definition.
the definition section.
It's
So the full statute.
57527
Well, okay. I mean, we can,
We can continue asking
Yeah, we're-
others with questions and then come back to that.
yeah, so, I mean, my concern is, and I would be interested in seeing how this is addressed in the state statute, is just that, I don't want it to be so broadly written that, if an attorney advises his or her client not to speak to the police or, not to show up, are they in violation of our city ordinance?
That's one I couldn't answer.
All right, so I'll wait till we get with state statute and then maybe to the police officers come and able to testify. I'll hold my breath.
Okay, we'll move on. Alderman Vaccaro? Okay. Alderman Coulter?
I don't have any questions this time, Mr. Chairman.
Alderwoman Spencer?
I don't know that I have any questions at this time. I want to see, I'd like to see how this compares to what we currently have. Do we have anything currently on witness tampering? This is-
Only the state.
Tim just went to get the state,
But that's
yeah.
just at the state. In the city level, at the municipal level, we have nothing?
No,
There's
that's
nothing.
why
Okay.
that's why this was kind of, you know, came up through the police, that, you know, it's a tool,
Okay.
another tool that they could use.
And so I don't have any further questions at this time.
Okay. Alderwoman Green?
Yes. I'm wondering if you talked with anybody at Crime Victim Advocacy Center with any of the domestic violence shelters regarding this legislation?
No.
Okay, because one of my concerns, particularly with this, is if you have a woman who's in a domestic violence situation that is an ongoing situation, she often feels pressure from the abuser to not report, not testify, out of her own safety. And I would hate to see a victim of domestic violence put in a situation where he or she is having to choose between, you know, getting a fine because of bowing to that pressure and his or her own safety. So I would be interested to hear a perspective
Well, I don't,
addresses that.
my opinion, this isn't targeted at the victim, you know, and, I mean, it's targeted at the aggressor, the one that's, you know, telling that person that they're threatening that person and saying you shouldn't show up in court, you know. I mean, you know, I'm pretty involved in the nuisance system, and, you know, the one thing that I'm pretty big on is protecting the victims of domestic violence. And in fact, when I see that on the you know, our runoffs that we do, I always ask if it's been referred, you know, but to me, this would more protect that person, you know, than, and that's just what it's for. When the abuser, and normally when something like that happens, there's a case, and then if that person comes up and threatens that person not to testify, they would be the ones that would get issued the summons, not the victim.
So, but you often see in these cases, beyond just the abuser, putting pressure on folks to not report for a variety of reasons. It could be a relative, it could be a friend, just because it's a very dangerous situation and they're concerned about retaliation. And so I would be hesitant without knowing, you know, if somebody is advising somebody for their own safety to not report something, how that, you know, would play out in this?
Well, that, in my opinion, wouldn't be witness tampering. You know, the witness tampering is when you're already a witness in a situation, and, you know, domestic violence is a whole, you know, whole new situation, you know, because every case is different. I mean, I don't know
But it
of any.
says in it, purposefully prevents or dissuades or attempts to prevent or dissuade any person who has been a witness of a crime or victim of any crime, or a person who is acting on behalf of such a witness from A, making a report, causing a complaint. My interpretation would be that that would be in there. It's very broad.
Are you seeking a legal opinion on that?
I'm
or-
trying to just understand, like, how broad this goes.
Okay.
This is just that red.
Do,
Yeah.
are you hearing her question here?
Just, I guess, from a legal standpoint, how broad this goes. So if a family member, a friend, or neighbor, whoever, you know, tries to tell somebody not to report something out of fear for their own safety, does that fall under this?
You know, I think two things. I think that all criminal statutes give a certain discretion, A, to the prosecutors, and B, to the police. Ultimately, judges have to decide whether a given fact situation actually fits this scheme. I do not think so. I don't think that it's that broad. And I can say that this uses the words exactly as they are in the state statute.
Okay.
Almost. Okay.
Okay, but no victims' rights organizations were talked to when drafting this?
Not that I know of.
Okay, thank you.
Okay. We'll go to, I think, Alderman Spencer, then back to Alderman French. You had another question?
I did. Thank you, Mr. Chairman. This is obviously a very important issue to deal with, and I commend you for taking this up because we've talked about how we have witness and victim. This is a very important issue. So, like I said, I was commending you for taking this up. Have we worked with victims groups and witness advocacy groups and vetted this in some way with folks that are really concerned with the issue? The reason I'm asking is just because I haven't heard a lot of movement around this, and was just curious if we kind of roped in some of the Circuit Attorney's Office, for example, has been very vocal about this particular issue, and I was just curious if they weighed in on this.
The city councilors have, but,
Sure.
you know, one of the city councilors actually drafted the first draft and sent it over, but it's more police-driven.
More
Is what it
police-driven?
is, yes.
I think it would, I would imagine it might be a good idea to rope the Circuit Attorney's Office in, just because they work with so many victims and witnesses in their office and have experience. I've spoken with their office several times about this particular issue and it being such a serious one, and was just curious if it's my understanding from my colleague, Alderman Coder, that it's very similar to the current state statute, and so from that perspective it makes a lot of sense to me, and I think that's a good place to start, and was curious how it fits in with best practices across the country with this issue, and if we've looked beyond just our state statute on this issue.
Tim, do you,
So, did you hear my question, Mr. O'Connell?
No, I didn't.
Well, so no, and so I was just, it's such an important issue. It's one that we've talked about several times. We know it to be a very, witness tampering, witness intimidation is a very, very serious issue in the city. It's something that I've spoken with the Circuit Attorney's Office several times, and many of us on this board have. Many people in this room have, and was curious if A, the Circuit Attorney's Office was brought into this conversation, and B, if it's my understanding from my colleague Alderman Coder that this is very similar to state statute. I think it's a very good place to start, but I wondered if we had looked a little broader than the state of Missouri, who might not always be on the front end or the progressive end of things, and look to best practices across the country with regards to this issue.
I did not talk to the Circuit Attorney's Office about this, and I did not know. statutes in the South Missouri. One point I might make, the circuit attorney's office has recourse to bring charges in the state statute.
Okay.
So, I mean, it seems to me, I don't know, if there's ever been ordinance spoken in this. The point of this is really to,
Give the police. Okay.
I mean, that's my understanding.
At the city level.
Okay.
Because they, you know, the circuit attorney's office, you have to actually make your case, and, you know, it's just more complicated to get the state to issue on witness tampering, where, you know, our city police are out here every day in the neighborhoods, and, you know, they're trying to protect the good people, and if there is a case like that right now, they can't write anything at all. We don't have that tool.
I understand. Okay, thank you for that clarification.
Alderman French?
Yeah. So now that we have the state statute, we have to look at it, and it is almost word for word what the state statute says, except in section 2, subsection 2C, page 3. It says it differs in that it says arresting or causing to seek the arrest of any person, comma, and this is additional, or engaging or seeking the engagement of any agency of the city of St. Louis. So that would say that it goes beyond the scope of just, it's beyond just telling them not to cooperate with police or the city attorney. It is also, you know, telling them not to cooperate with the health department or refuge department.
So this is just kind of just.
So if, you know, if somebody comes to me and says they saw somebody illegally dumping in the backyard, and they say, should I bother calling in and going down there and file a report? And I'm like, don't worry about it. Have I committed witness tampering? Tim?
You know where I'm going to defer to, so.
So, you know, I considered this being my response the first time you guys asked me for a legal analysis of a bill that's before you, you know, in the middle of an open hearing. My normal advice to clients as their attorney would be that we have those discussions one-on-one.
Okay. Let's research it.
So, you know, I mean, if that means that,
I don't want to put you on the spot.
if, you know, if this is the first time that you've, I mean, it's the first time I've been asked to answer that question.
And that might be a question we'd ask the police representatives too. Or the, who would this be up to? This would be up to the city councilor to prosecute?
It would be city councilors.
City councilor around?
He's right there. The acting city councilor's here.
Maybe the city councilor could come up and
Be
ask.
appointed. They may not be prepared either.
Mr. City Councilor?
Do you want?
You want to have Mr. Garvin come up?
Yeah. Is he aware?
I think you did look at this, but I don't want to speak for you, the witness
look at it.
tampering.
I apologize, I was in another conversation. I didn't hear.
Or if you would like more time too, I don't want to put you
Yeah.
on the spot, but there's a section here, in general, almost 99% of the language just mirrors the state statute, but there's a section on page 3, the section C there, that adds that, or engaging or seeking the engagement of an agency of the city of St. Louis. So to me, that sounds like it goes beyond just interfering with the cooperation with police or the circuit attorney, but or just even law enforcement. It would be any agency in city government. Again, I go back to the example. If I tell somebody, don't worry about reporting that littering you saw. Am I tampering with a witness?
I'm speaking off the top of my head here. So, I don't know where that provision came from, and I'm not sure what motivated it. I assume it was to prevent city officials from being approached by influential people trying to prevent things from happening, to put some legitimacy in the entire process. That's my off-the-cuff answer. I don't know what's behind that provision.
Yeah. Okay.
I don't have any other questions.
You don't have any other questions? Thank you. Thank you.
Thank you.
Are there any other questions? Alderman, did you?
Sergeant McLaughlin just came in, so he could speak somewhat,
You have
maybe.
Alderman Vaccaro has something before we have him
Just,
speak.
because I know, given the time frame and meetings that we have left to get any legislation through, would you have an objection if we took that line out? I'm not trying to change your bill, I'm just asking. If it would help to get it passed and through, would you have an objection if we took that out? And it's just a curious question. And
I would do anything to make it better, but I think we need to hear from the police's standpoint first.
Okay.
So, and
Okay, I was just,
the question is why this was, sorry,
What's the line?
why this was put in.
Page,
In the bill, page 3?
line 2 and 3.
Line 2 and 3.
on the bill itself, right?
On the bill, line, page 3, line 2 and 3. Or engaging or seeking the engagement of any agency of the city of St. Louis.
I'm trying to find it.
Engaging or seeking the engagement of an agency of the city of St. Louis.
Engaging.
Would that be other
So
city
take the section
agencies
C
like the
out.
Health Department or Refuge or something,
Well,
if they
not the whole
witness something?
section.
you know?
Yes, it would be.
This is the only part
Yes,
that was
absolutely.
added.
So take that one line out.
It would be what?
You want to speak to that?
It would be,
Can you come up to the microphone?
pertain to other,
Can you come up
it
to
would
the-
pertain to other city agencies as well, health and buildings division inspectors as well, so.
So in that way, it is an expansion beyond the state statute.
No, it's not an expansion. Well, the attorney says yes, so,
Okay. All right, that's it.
So if I understand it correctly, you're saying that if a witness or someone causes or tries to attempt to make a witness not appear or speak to a building inspector or another agency of the city, that would be considered?
that'd be a criminal incident that we're looking at, a
Okay.
criminal incident.
Okay.
Now, we have another charge, intimidating a public official, which I believe that's probably what we would use in those instances. But this is really for people who are affected by trying to work within the process, calling the police when we need them to call the police on criminal behavior. Yeah, every time we go to neighborhood meetings, they talk about being intimidated by persons that live around their house. We want them to be engaged, even as a witness. If they become a victim of a crime, we want them to be able to know that we can quickly address those issues through the city summons, before they get to the point where we have to rise it up to a state statute, the state charge.
Alderman French?
But that's already against state law, and it has a much harsher penalty, so.
It's against state law, but we don't have a quick remedy for that like we do with the city summons, so it doesn't get as big. It could become a bigger problem. If we can address that quickly, calm people down, calm sides down. If there is an issue between certain people on the block, we can bring in mediators, but that allows us to do that through the summons.
I mean, witness intimidation is a very serious thing. I mean, are you not getting the support you would like from the circuit attorney's office in those matters?
Witness and victim intimidation is very serious, and it can arise to that level, yes. To make that case, and we just got done making one in down south, it is very, very time-consuming, and it should be. But if we can have a quick action to somebody who's threatening somebody, particularly, let's say that they put up a cease and desist letter next to a neighbor next to their house, and they call the police because of the activities going on there. If I can quickly get a summons to that property or to the person who threatened that person who lives next door, I think I can alleviate that getting any worse than what it could be. That makes sense.
So can't you reach your same goal by not extending this to the health department or a committee of the Board of Aldermen?
I can live with that, yes.
Okay.
Absolutely.
Okay. You have another question? Go ahead. Alderwoman Spencer?
I do, thank you, Mr. Chairman. So if I understand correctly, these lines 2 and 3 are, protecting the right. So if somebody is intimidating a witness who is going to the building division to turn in that the neighbor's house is crumbling or whatever, we're saying we're not going to protect that action. We're not going to consider that witness intimidation. We're only going to protect them if they're going to the police department, not if they're going to the building division or the NSO. And
Yes,
I am asking. That's the way I'm understanding it. Hi. And so, and I'm just trying to better understand if we do remove, if they remain in here, and because I know a lot of our victims are not going directly to the police department, they're going to the NSO, they're going to our city, to our problem properties, counselors in the city counselor's office. They're going to me. They're going to aldermen, et cetera, and I don't want them to be intimidated to continue those actions, especially folks who, frankly, don't feel very comfortable going to the police department for whatever reason, and if they're choosing to go to other city agencies to get to the police department, and the police department is taking action appropriately based on those, I want to protect that as well, if possible. But I don't know. I mean, maybe.
So I would just say that then be specific. Because with the broad language, I think it is very broad and would cover someone not reporting that the neighbor is stealing cable.
Sure. Okay, this is a fair point. So I'm specifically speaking on an instance in which I had a neighbor who was turning the neighbor in for illegal dumping, and they were making those claims to the NSO and myself. And then that person was then threatened by the neighbor for continuing to turn their actions in. And that is witness intimidation in my mind, even though they didn't go directly to the police department. They were turning those illegal behaviors over to the city agencies, being that neighborhood stabilization team and myself.
So would that have been covered by the state statute?
So I'm a little bit
I would say no. That would not be covered. We have to deal with a criminal incident. So the criminal incident is reported as the illegal dumping. Then the police department would be reporting and investigating that illegal dumping. That's the first part of the criminal criminal act. And then if the person who's been calling is then intimidated or the witnesses has been calling, then we could take action with a bill like this. But to call a city agency like the building division or health without first reporting the incident to the police department, I don't think that would cover that.
with the state statute, so this would. And I
think the state
suppose- and I
statute
think
would cover that either.
the question is valid. I don't know what the answer is. I was thinking in terms of specific instances where it would be helpful to be able to protect a witness or victim.
It is a witness.
I think it just comes down to the language. I think what we have here is too broad, and you and you think without it, it's too narrow. So we have to find a happy medium.
Yes.
Yeah.
So did the mouse.
I'm also
Right.
okay
Okay.
taking it out. I think this is a good question. I just was, if we're going to make a comprehensive, tool that is helpful.
Mr. Chairman, I wanted to introduce, this is Officer Daphne Allen. She's the 3rd District Problem Property Officer also. So, because you kind of gave that look, it's like, who's that?
I didn't know who you were, that's all. Thank you. Did you have something else at this point?
Just
Mr. Chairman,
one
if I may.
more
Do you have something,
question.
Alderman Green? Go right ahead, finish yours, and then we'll go.
So a city officer cannot issue a summons for somebody this is against state, we have a state statute preventing, victim tampering. An officer cannot issue a summons based on the breaking of that law?
No.
No, it's a Class C
So
felony.
okay,
Not
I
today.
understand.
Alderwoman Green, you had something?
Yes, I'd like to ask you the same question I had asked Alderman Ortman before you came in. have you talked with or consulted any crime victim advocacy groups with regard to this piece of legislation?
No.
Okay. Is there a reason why?
No, there's no reason why. This is to protect those persons who come forward to talk to this. So I don't see why they would be not in favor of such legislation to protect those victims or witnesses.
But there's a lot of reasons that people don't report crimes, and I was talking to Alderman Ortman specifically about domestic violence victims, and that there's often a lot of pressure from relatives or friends or whoever not to report, what's going on, and there's a lot of safety reasons for not doing that. And I
would then not affect them because we wouldn't be able to charge anybody with this unless they would come forward.
The one thing that we have to remember is there's got to be a criminal act first. So, and I think we're kind of getting, before that. That's, where some of the questions are. There's got to be that incident where there is the criminal act, and then there is a witness involved, and then that witness is threatened or, some way where somebody's saying, don't, you better not come and testify against me.
Right.
That criminal act has got to be there
criminal
first.
act is an abuser beating up the abusee, and the parent or whatever saying, I don't want you to come forward and talk about this because of X, Y, and Z issues. I don't want you to report this. I don't. It could be a family member that did this. There's a variety of reasons that these things aren't necessarily reported to police, and a lot of it has to do with the safety of the victim or their family or whoever. And so my concern is really getting those kind of unintended consequences of getting somebody that's in that situation who maybe has some very legitimate reasons regarding their personal safety for not coming forward.
Yeah, go ahead.
The case I had, we had neighbors, so it wasn't domestic. And it didn't involve, relatives or anything. It was neighbors. And this gentleman bullied everybody on the block and intimidated them. And finally, we were able to make a tampering with a witness case because he directly threatened him and said that he should redact everything that he said to CSB. He should redact everything that he said to the health department and the police department. He wanted him to write an affidavit and hand it over to those different agencies, ours included, and threatened to shoot him and his wife if he didn't do these things. And he also continually threats the people across the street from him. Now, what we did is I got the state charge issued for tampering with a witness, but it's the state can be a little bit daunting with their process. So, getting it issued finally, and my victims were also elderly and handicapped, so, I had to convey them down to the circuit attorney's office and help them with that. And then in addition, I had to help them get restraining orders, and we've got a hearing for that coming up, but it hasn't happened yet. And again, they'll be going to the grand jury on what I got was a stalking first charge, 2 stalking misdemeanors, and then the tampering with the witness. But again, it's far out, and that in-between time is the scary part. And I think what we're looking for is just expediting the process. So I think that this would be really effective because we could have more immediacy, as opposed to waiting months out to have a hearing to get an order of protection, or months out before they go to the grand jury. There's just so much lag time. In the meantime, these people are living their lives in fear. So that's what's really on this block. We've got a flag on this guy, and we've got cars going up and down the street, sergeants going by, but they can't go out on their porches. The other day, he was, the other gentleman that's involved, just to go out to his car to get in to go to work, he's afraid because the suspect, the offender, he waits out on his porch. So it's just like these are real people and real problems, and, we just really need quicker, like, and
So
more
it
immediate.
seems to me like the purpose of this, or the end result of this, is to try to get more people to report to the police.
Absolutely.
So my question is, do we know the efficacy of such laws in actually compelling that to happen versus building better police-community relationships to facilitate a feeling of comfort to come forward and talk to police, even if there is a fear of retaliation?
Well, I mean, we got these people to come forward. The police department, the prosecutors in the city councilor's office. There's something more approachable about the city services, or even our city courts. They move quicker. Everything's more, immediate. And again, the prosecutors engage more. We deal with the community all the time, so it's something that we're used to. And, the neighborhood stabilization officers as well. But we're more on the boots on the ground, so I think that they would respond better to something in the city charter, an ordinance that we could act on quicker, and I think they would feel more comfortable. I think people would feel more comfortable. The process moves just so much faster.
The longer something goes that we have to deal with it, the less people become more problems.
They drift away from us, yeah.
It helps us with orders of protection. It helps us allow the person to come over to the circuit judge and show them that this is an issue so they can get an order of protection. And in the case of the domestic issue, a person would have to go forward before we would be able to move forward with this. So if somebody doesn't, like a grandfather or a parent doesn't come forward, this wouldn't apply to any of that.
No, and the orders of protection are tough. If you're not in a domestic relationship, they don't want to issue those. Mm-hmm. They just do not. But I mean, if we had something in the city on the books relative to, tampering with a witness, I think that would be really helpful with orders of protection as well. Instead of these people are prisoners in their homes,
I've worked at a variety of women's organizations, and so
Yeah.
I'm very familiar, and that's
Good.
my concern is some unintended consequences from this bill that maybe we haven't thought through because we haven't had those parties at the table. So that's where my concern is.
Alderman Cone had a question.
Thank you, Mr. Chair. So I'm curious. I know it's a very short piece of legislation here, 4 pages, but is there a requirement in here that the police actually have to witness the witness tampering taking place, or how are we going to avoid the he said, she said situation? Because, I mean, this will pop up everywhere, I would imagine. I have neighbors that call me that tell me a very different story than the neighbors that I talk to next door to them.
We will I know exactly where, we have a lot of people just don't like each other,
right.
And they could try to abuse, but they can try to abuse anything. They try to abuse the problem property process.
And they do, and they abuse 911 already. So my fear is that we're opening up a can of worms with this if it's not specific to something that an officer would witness themselves, right?
We vet, and in this case, I mean, I had a lot of. I got an amazing amount of information. I mean, and I had dealt with him personally.
So can I?
Offender, because I attended mediation.
And that's kind of my segue into my next question is like right now this is also very broad in terms of the laws that it applies or the witnesses that it applies to. If we narrow those witnesses down to, let's say, nuisance properties, narrowing it down to, witnesses who witness activity at a nuisance property type of a situation, because I have my own example, which I know Sergeant McLaughlin is very familiar with, but, there's a property on my block actually that has quite a bit of activity, over the time that I've lived there and even, during my time as alderman. I've had my life threatened by people that live there. I've had, young people, as old, or I should say as young as 8 years old, who have gone around after gunfire has gone off, yelling at neighbors and calling them snitches because they're standing out on their porch, on the phone calling the police. So, and it's when gunfire is going off, on the front porch or inside the house, that in itself is intimidating neighbors, right? And so, and the witnesses that are hearing it. So, but the police show up and there's 8-year-olds that are running around, yelling snitch and this and that, to the neighbors that are standing out on their porch while the police are right there. So are the police going to write an 8-year-old a summons for, intimidation? Because, I'll be honest, some of my 65-year-old neighbors feel intimidated because that 8-year-old has a parent that has a gun that was just discharged, in the house across the street from them, and so they do feel intimidated by that as a witness of something that just happened that's illegal, right?
Alderman, first of all, and you came in a little late, so, the criminal act has got to happen first. And if there's a criminal act on your block and you're a witness.
And I just explained a situation where a criminal act just took place. I was here 5 minutes late and I heard most of the last 40 minutes of conversation.
Where charges filed, is there that incident? And that's what's got to happen, where you would step up and say, officer, I witnessed this, and then the neighbor across the street or wherever would come up and say, you better not go to court. That would be the witness tampering, where someone's tampering with you and telling you not to.
I understand that. That's not my question. So I understand what witness tampering is, but I think the issue that I'm having with this is, one, sometimes, as a witness, and I include myself in that along with half my block that witnessed this last particular incident. But, there were 8-year-olds that were running around threatening people, and when the parent of the 8-year-old has a weapon and, just discharge the weapon, it makes people afraid. I'll throw myself in that category. Did I still call the police? Would I be happy to testify? Absolutely. But can I say the same thing for my other neighbors? No. But are we going to write a summons to an 8-year-old, for going around yelling at neighbors and threatening, their physical or, property's well-being? I can't imagine a police officer doing that.
Well, they wouldn't, because juveniles are treated in a different manner.
Right. But so how, but it goes also, if the officers are there, right, I can understand the officers writing a summons. But if the officers aren't there, I feel as though we're opening up a huge can of worms, for situations like domestic violence, like, other crime, like dog poo, it's a real thing. I've literally have had conversations with neighbors that have lasted an hour over someone's dog taking a poop in their yard, and is it against city code? Probably. Is there a witness? Yes. Has the neighbor been threatened for calling the health department on the neighbor for the dog pooing in their front yard? Yes. Are the police going to start writing summonses for witness tampering in those situations? Probably not. But is it opening up a can of worm where we're getting even more 911 calls for, witness tampering? Potentially, and so my kind of mental framework around this, my perspective, if it's the officer who is there on the scene and is witnessing this happening, or if there is documentation that this is happening, which is the case that you had with your property, I understand that the burden of proof is a lot more when there's a felony charge that's associated with it, and therefore that's why, there's that, due process that happens, with the state level charges. So I know we're just asking for a little bit more flexibility in terms of the burden of proof that's required and allowing some expediency in the process as well, because there wouldn't be a felony charge associated with this. It would be a municipal violation. So I get that, but I think that we need to confine, because it is a municipal violation. I feel like other municipal violations are done based off of a direct sight from a building inspector, from an NSO, from a park ranger, from a police officer, right? The citizen isn't the one that's writing the summons. And I think in this case, since we're not requiring, direct line of sight from the police, that, and whether that's evidence, the police can review evidence, right? So, someone has video, someone has letters or emails or Facebook threats, that's evidence, right? And the police can witness that evidence and then issue a summons. But the police are seeing that, and it's not just based off of, oh, my neighbor called 911 and said that, we're being harassed and we witnessed, activity at nuisance property kind of a thing. So I would like to have just some language added to the bill that provides some clarity that this has to be directly witnessed by the police in order to receive a summons. Otherwise, I think it's just opening up a can of worms.
It's very rare for somebody to, and usually there's always a pattern. There's peace disturbances at the house, or the neighbors have, it always ends up on our radar, usually problem properties, because there's, the neighbors can't get along, or, there's a lot of peace disturbances, general or individual, tampering with a witness. I mean, it's, this really hit our radar screen because this process just ended up being so daunting, with it.
And I agree.
Yeah.
I wholeheartedly agree. So, which is why, we should either confine it to nuisance property related witness tampering, because, they're neighbors, and it's a very different situation than you would have with a domestic violence situation or with, theft or, anything, I like the bill in theory, it's just kind of the nuts and bolts I think need to be worked out a little bit.
I like the idea of narrowing it down to the nuisance process. However, having the police officer be the only witness to the incident. We right now, individual peace disturbance cases where the witnesses' statements are taken into account, and the charge, a municipal charge of peace disturbance is issued. So we have to conduct a thorough investigation before we write those cases. So I think we'd have to do the same with this.
Mm-hmm. Okay. Alderman Coder.
Thank you, Mr. Chairman. And Shane, thank you for, Alderman Cohn, thank you for some of those questions. I think we agree on this one. Sounds like the problem we're primarily trying to address here is within the context of problem properties, nuisance properties, neighbor disputes, and neighbor intimidation, stuff that doesn't necessarily rise to the level of a felony tampering with a witness or victim charge, which is a very serious charge. And Officer Allen, you've mentioned that's a daunting process. And I've prosecuted those cases. I've reviewed those kinds of warrants. It's a daunting process because it's a very serious criminal allegation. It's a Class C felony carrying a range of punishment from 1 to 7 years in the Department of Corrections and/or a fine of up to $5,000. That's probably not an appropriate, punishment for a dispute between neighbors over grass clippings or broken windows and things like that. So I get why you guys are looking for some sort of intermediate step, and I think the municipal courts probably are the place for that. State court moves much slower, has much more serious ramifications in terms of the penalties, what goes on your record, whether we're talking about a Class C felony, which is the current law, or next year after the new criminal statutes go into effect in January, I believe it becomes a Class D felony and or a Class A misdemeanor. Both are still very serious. A misdemeanor charge can go on your record, your permanent record, can be looked at by employers. Obviously, felonies can be. So having some sort of process in the municipal courts to deal with these lower level witness and victim intimidation situations between neighbors and things, I think does make sense, and I commend you guys on your efforts, and I will support those efforts. I think as written, simply mirroring the language of the state law and adding some provisions regarding police investigations, legal proceedings, administrative hearings, board hearings, maybe needs to be tightened up, and I'd be happy to work with you guys on that. But I ultimately hope we can get a bill through this committee and to the full board that does help you guys deal with these situations where you're trying to diffuse neighborhood situations, where you're not interested in locking someone up in the Justice Center, where you're not interested in going to the warrant office, dragging neighbors down to the warrant office on a Saturday morning to deal with these kinds of disputes, what are probably more appropriate for the municipal courts. So I think, am I out of turn? Am I speaking correctly? Is that the intent of this bill? Is that what we're primarily dealing with? Okay, and maybe some of those other instances where, because again, having sat in the circuit attorney's office, Chapter 575, 270 does not get charged very often. It gets charged in those instances where someone's life's being threatened, where we have rock solid evidence of a threat to someone's safety, whether in writing or verbally, and it can be corroborated generally. That's about the only time that gets charged. It's very rare. But I do think there is a place for that maybe in the municipal code, and I'd be happy to support that.
Defusing these situations early and letting the municipal judge allow neighborhood mediation is the way to go, and that's what we're trying to do here.
Thank you, guys.
Alderman, did you say you were willing to work with them?
I am.
Okay, thank you. Just one other, Alderwoman Spencer.
Yeah, thank you, Mr. Chairman. Again, I echo Alderman Coder's commending of the work here and recognize, I've worked with both Officer Allen and Sergeant McLaughlin and in a very careful manner with this is a very serious issue. And so I think I also echo the support of the idea behind this and moving this forward. I think it would be helpful to have a broader panel, and so I'd like to invite maybe the Circuit Attorney's Office, a social justice organization, just to kind of weigh in on this as well, so that we're making sure that we have all the perspectives in the room that we need to when we're creating essentially a new crime in the city of St. Louis. Thank you, Mr. Chairman. That's all.
Okay. There were a number of other ideas with you, and Alderman Carter has. Coder, pardon me, is willing to work with you. I think it might be good if we hold it and then have another hearing next week. We already have one scheduled. And with any changes, and get it passed out then. It still gives enough time to get it finally passed before we go on break. Okay?
Thank you.
Thank you, and we do appreciate your effort here. And as you see, there's broad support for the concept of doing it. So thank you very much.
Well, the whole intent is to protect the good guys, the guys that are willing to cooperate.
Exactly.
So.
Exactly. Okay, thank you. We will now take up Board Bill 296. Alderman Ogilvie. We'd like to thank all of those who've also come today to testify. We'll now hear from Alderman Ogilvie.
Great, thank you. I'm excited to talk about Board Bill 296, which deals with keeping of animals in the city of St. Louis. As you guys probably know, St. Louis is a great climate for a lot of gardening and urban agriculture. You can grow everything from asparagus to zucchini here in the city. Many people do. And last year, a number of people came to me kind of all at the same time and said, let's take a look at the laws the city has that deal with keeping of animals, with gardening, with urban agriculture, with produce sales, and let's think about how we can make it a little easier for people to grow and distribute their own food locally. So the first result of those meetings is this bill. I think hopefully there's some other bills coming in the next session. But this bill deals specifically with animals, and specifically with animals that people keep or raise that are egg-laying or for food. So what this bill does not touch on, just to be clear, it does not change any of the rules regarding dogs, cats, pot-bellied pigs in the city. It does deal with fowl, so ducks, chickens, geese, rabbits, as well as if you can meet certain site requirements on larger lots, goats and sheep. As you guys probably know, right now you can keep up to 4 chickens in the city. This bill would allow homeowners to keep 8 chickens. And then if they had 20,000 feet or more that was their property or adjacent to their property, they could keep additional chickens or rabbits. If they had 20,000 feet or more, they could also keep what we're defining as livestock animals, which is a new category in this bill. And that category is basically goats, sheep, and emus. Is there a enormous demand for keeping emus in the city? Probably not, but but since we're looking at kind of loosening the rules on what's allowable, we thought we would include some animals that people may be interested in keeping and raising. The city, right now, the city is kind of in a middle point at a lot of animal rules. There are some municipalities in St. Louis County that are much more restrictive, but the rules in unincorporated parts of St. Louis County are actually very permissive. They allow you to do a lot of different things, even more than are in this bill. So I was trying to move the needle a little bit towards allowing people to do more, still recognizing that it's an urban environment that, you know, it wouldn't be appropriate to be living next to 8 pigs or something. I think what is exciting about this, and I think why people are here, is we went through a long phase in this country where people got very detached from where food came from. You know, the industrial agriculture model. You know, it wasn't that long ago, before that period, where it was very common for everybody to have a garden, almost everybody to have chickens, and for people to grow a fair amount of their own food. We got away from that, but I think many people are returning to that idea and utilizing the property they own to produce a lot of things that they consume and that they give away. And I think that's why a lot of people are here. I want to thank people for coming to testify on this. And I'm happy to kind of walk through the specific changes. I think you guys have kind of a redlined copy that highlights the changes made in Chapter 10 here, or I can take questions. And I guess I'll also say that so the specific language in the ordinance originated with the Missouri Coalition for the Environment and with a class at Washington University. Then we kind of drafted some changes. We took them to the health department, which has enforcement authority on animals in the city. They read through them. They made a couple suggestions that we incorporated into the language, and then we introduced the bill. So what else can I tell you about it?
Well, let's say we have some questions. Alderman French, did you have any questions at this point?
Not yet.
Okay. Alderman Vaccaro, any questions at this point?
Well, as much a comment, I mean, we're here, what, last year or the year before, because people were complaining about roosters making all kinds of noise. I know, so I had someone with a peacock that was calling for a mate that I probably got 36 calls for. I mean, I would think there was reasons we put all that stuff in place back a ways. It wasn't one day we decided we hate roosters. It had to do with, you know, complaint-driven issues.
Sure. So roosters are currently prohibited, and they're still prohibited within this language. So they're specifically prohibited. Peacocks, I don't think, are mentioned in the current ordinance. They may not. They're not one of the animals that would be permitted by this ordinance. I think they fall under a different category, which is exotic animals. And I think we have a category for that in the code, but I'm not 100% sure. But if they're not specifically permitted, I think by this part of the animal code, they are probably prohibited. So peacocks are probably already out and would remain out, as far as I understand.
I don't have personally have a problem with more chickens, but I have, you know, of course I have a farm, and so, I mean, I've raised goats and sheep and all that, and goats tend to like eat everything green around them, including the trees, and they also have the ability of jumping fences and getting out, and they make it, I know, so do dogs, but they also make a lot of noises, and, you know, I mean, I just look at how many complaints we'll be getting, you know, and then how you house these things humanely, you know, I mean, I don't know. I mean, I know that there is a formula for, you know, horses and stuff like that we follow whenever we get anything on a farm, because they have to have a certain amount of nutrition and a certain amount, you know, you're supposed to have so many acres per, you know, cow and per, you know, so like I said, I don't have an issue with more chickens, but I think some of the other stuff I probably would really have an issue with.
Right, so goats and sheep. So those would be new animals that the bill would allow. To keep those animals, you have to have at least 20,000 square feet. So that's about 4 or 5 times the size of a typical property in the city. And you have to live there. So you can't keep them off-site somewhere. So the number of people that have 20,000 square feet is a pretty small percentage of residents of the city. And then the number of those people who want to keep goats or sheep is probably a pretty small proportion of that. So I think that I'm sure there will be some people who will want to do it and will do it, but it's a relatively, I think, small number of people. And there are some site requirements within the bill. So they have to be kept 10 feet from a property line. They have to be kept 100 feet from the dwelling of anybody else. So you couldn't, they have to be contained to the back of the property. They couldn't be, right up against the neighbor's house. And the health department, by keeping any of these animals, you permit the health department to inspect the premises at any time and to make sure that the animals are safely contained and cared for.
Alderman, you anything? No. Alderman Cone?
Yeah, I thought I was actually a co-sponsor of this bill, so if the clerk could add me, I would appreciate it. So how did we come up with adding radite birds like emus and ostriches and not an animal like a llama? Like, where did that come from?
I don't know. Do you want to substitute llamas for ostriches?
Llamas are very popular in hipster culture, so I just thought, why not add them?
I wouldn't argue with removing ostriches.
The only reason I'm bringing that up, and I know I'm doing it in a joking manner, but so an emu and an ostrich, they're the fastest birds on the planet. So I'm not sure if our health department is necessarily equipped to chase after an ostrich if it gets on the loose.
Right. It's funny, but it is actually a concern. I mean, it wouldn't bother me to remove ostriches.
Okay.
Emus are smaller. I mean, they're big, but they're smaller.
Well, the language in here is radite birds, which would qualify all of them as such.
Why don't you make a motion, Alderman?
Does someone have an amendment for that?
We have an amendment.
Then I'll table that conversation until later.
So I think you bring up, it's an interesting point. Like, how far do we go? We could say you can do anything. We'll just let the state rules on keeping animals apply. That's not appropriate for an urban environment. We could say you can't keep a single chicken, which is what some municipalities do, and I think that's silly and not appropriate either. So we're just trying to find kind of the right balance of what that is.
I really appreciate that. This. I've raised chickens in my backyard before my neighbor's cats ate them. I think that you're absolutely right that, folks are trying to become a little bit more connected with the food that they're eating in today's society. So I noticed that there's language in here in terms of like where coops should be built and kept and maintained, and, also the amount of land that would be required for livestock and all of that. Is there language in here in terms of fees that would be associated with keeping farm animals? So, do I need to have a license for keeping chickens in my backyard?
Yeah, you do not. You don't currently. And you would not under this ordinance.
We're not adding language.
We're not adding that for chickens. Yeah. I think that it wouldn't be crazy to suggest we do that for the livestock animals, but chickens are really a pretty low impact species, especially compared to when you think about dogs or cats. I mean, cats are out killing thousands of birds all the time and doing all kinds of stuff. So, a chicken is a much lower impact animal than the domestic pets we normally keep. So I don't think it's appropriate to require a license or a permit for chickens. Goats or sheep, maybe just to make sure at least that you've got the correct space to keep them. I don't know that that would be out of line.
And along those lines, beekeeping is a very popular, I guess, side occupation or, hobby for some folks in today's environment as well. Something that I'm exploring doing myself. But I know that, that brings its own set of challenges in an urban environment as well. So not trying to address it in this bill because, I'm very supportive of this, but I think that we do need to have some conversation down the road in terms of like what urban agriculture looks like and, including as many facets and as we can to make it not only legal but accessible, easy to manage, but also addressing, neighbor issues as well.
If I recall correctly, I think the state actually has some reasonable rules on beekeeping.
They do.
That apply.
And I had a conversation yesterday with the health commissioner about this bill, and she expressed her support over the bill as well. The item that also is not in here that may be governed underneath state statute, but if we're going the route of implementing local ordinances around this, we should probably be somewhat comprehensive to the best of our ability. But the exotic animal language, I remember a couple years ago we had a dragon monster that got loose in Compton Heights and terrified a lot of kids in the neighborhood for a while there. So I don't know how many folks in the Central West End or Compton Heights are keeping tigers in their, basements or backyards or whatever. But, we might want to have some language around, exotic animals, zoo animals, and the like. And I know the health commissioner.
I think we do. I mean, I think all of that stuff is already.
She expressed that we didn't have anything at the local level.
Okay.
So if we do, it would be at the state level. And so I think it's something that's worth looking into, but I fully support this. I think it's way overdue that we work on these types of issues for our constituency.
And I'm excited to continue the conversation along some other issues too, and I think we have a really good group of people in the room who are ready and willing to help us talk through updating some of the other parts of the code.
I agree.
Alderman Carter? If I want to interrupt just a minute. We were also supposed to have a presentation today giving us an update on the city's comprehensive crime prevention program. I think we'll push that to another day. So thank you for sitting the hour or so far.
Thanks, Carl.
We'll make another arrangement for that one. So, Alderman Carter.
First, I want to thank you for pushing this bill forward. I thought I was a co-sponsor as well.
I sent an email. I know I sent an email adding you. I think I forgot Alderman Cohn.
Yeah. But one small technical thing that I may want to add to the bill in livestock.
Okay.
Could we add a cow in for every 20,000 square feet? One cow.
One cow. I don't know. I mean, you can make the amendment. What we try to do is look at what other urban areas permit, right? Off the top of my head, I don't know how much room a cow needs. I don't know how much a cow smells. I don't know. So, if we can figure that out, maybe. Okay. But I don't know that was one of the animals we kind of set aside, so I didn't investigate that too much.
And Alderman Vaccaro mentioned something that was interesting to me earlier during his questioning. The sound that a peacock makes when he's calling for a mate. Do you know that sound?
Do you want me to do my peacock call?
That's okay. Thank you.
Chairman's requested I not do that. So.
Alderman Coder, any questions?
Well, actually, I think Alderman Carter brought up, jokingly, the sound of a peacock. Are any of the new birds you're allowing, are they noisy? I mean, because I know we had an issue in Soulard with roosters and things, and I know roosters will still not be allowed. But are we going to have any animals that are going to be waking people up at, sun up? We don't like that in Soulard.
Roosters actually go all night long.
Yeah, I don't. Here, I'm looking for. But I'm looking for the definition of fowl that actually lists all the birds.
Fowl, yeah, bottom of the second page.
Oh, there you go. So chickens, hens, ducks, geese, pigeons, quail, pheasants. Some
Other fowl.
Yeah, I mean, none of those.
Excluded.
As somebody, I heard kind of a back and forth conversation about this, and somebody pointed out that, the loudest domesticated animal is a dog, really. So none of these would come close to making the noise that a dog makes, or a rooster.
Okay. Thank you.
All right. Alderwoman Spencer?
Sure, thank you, Mr. Chairman. And thank you, Alderman Ogilvie, for putting this forward. As you know, I'm a huge supporter of this bill and urban farming in the city and getting back to where our food comes from. It's a very, very important issue. So I commend your efforts on this and have a couple of comments to make with regards to Alderman Vaquero's questions, in particular with regards to the goats and the noises they make and their willingness to eat everything around. My 4-year-old human does the same thing. He makes a lot of terrible noises and he eats literally everything. I have to pull it out of his mouth. But
I'd like to address that.
Do what?
I'd like to address that.
No. Sure. No, I just mean, we have quite a few.
Is he outside?
My
all night
4-year-old?
Let's let her complete her statement.
No, he does. I do let him out, but outside, and he, But, I mean, in all seriousness, it is, the noises are an issue, but I think that we have a lot of really large animals, dogs, St. Bernards, Great Danes, other really large animals that are allowed under our current city ordinance, and while they do present an issue every once in a while, I don't think it's worth banning them for the few, overly zealous ones. As far as peacocks go, we actually have quite a few wild peacocks here in the city. There are, they roam down by the river. I live very close to them, and I don't know anybody who would want to domesticate them. They're sort of mean, but we do have a lot of them anyway. So hopefully, that's not an issue. And I just want to take a look around. There's quite a few folks in here that are very supportive. The executive director of Gateway Greening is here. A lot of folks are in the room in support of this bill. I think it's a great initiative. A lot of residents are very behind it, and I'm commending the effort here. And I just have a quick question, Alderman Ogilvie, if you could more clearly define when a permit is necessary and the permitting process, because permits are kind of mentioned through this ordinance, and if you could clarify the permitting process.
Where do you see permits mentioned?
Well, I mean, it's only as it pertains to, kenneling. So under what circumstances, a person wishing to obtain a non-commercial kennel permit shall make an application with a $40 inspection fee. So that's only for...
That's for dogs and cats. So that already exists. So a non-commercial kennel permit is for somebody who is not operating like you drop your dog off and they keep it overnight or whatever. But they want to have more than 4 dogs or cats. The health department has a process that they allow people to go through, and part of it is a neighbor consent process to permit more than 4 animals on the property. And some people have done that. It's not super common, but some people have gone through that process.
But so in order for me to keep up to 8 chickens, I do not need to get a permit or have an inspection. Is that correct?
That's correct. Although you do allow the health department to inspect anytime if you have chickens or have a chicken coop. So they can...
They can inspect.
Yes.
So if a neighbor is experiencing an issue and maybe thinking that you're not doing your chickens correctly, then they would call the health department and have an inspection conducted, in which case...
Just like the health department, if you call and you say, we think there's a dog next door that's not being cared for appropriately, animal control responds, checks it out, a lot of times talks to the owner directly, and many times just tries to talk through what is proper care, so that people are doing that.
And the health department feels very comfortable with this, and is that correct? And being able to address any issues as they arise, if they arise,
Yeah, so they were definitely supportive, and you know, they said that what we need to do, or what they thought we need to do, is more clearly going forward, if we're going to have a more kind of permissive environment, more clearly communicate to residents exactly what is and is not allowed. I think the city has one role to play there. I'm hopeful that kind of private nonprofit organizations who are interacting more directly with many residents will also help play that role. So people know, you know, what the rules are in an easy to digest manner. So that was one topic they mentioned. I mean, they did also mention, you know, okay, what do we do if we have, you know, an ostrich escape or something? Do we have a way to transport that? They talked about getting a trailer. You know, if ostriches are taken out of the bill, so be it.
Yeah.
I'll live with that.
And then my last point was just that we're not alone in this. Many cities across the country are going back and revisiting their animal laws, so to speak, and allowing for all the animals here. This is pretty similar to what you know we see in other progressive cities and urban areas that are allowing for folks to come back and keep domesticated fowl and other things in their city. And then my last question is just this word. Ratite. How do you pronounce that? I have no idea. Ratite. Is that correct? Does anybody know? We've been confused. It's ratite. Okay, got it. Thanks.
Oh, that was the question. Okay.
That was my question. I just didn't know if it was ratite or rat. Yeah. So, thank you. And I didn't mean to cut off Alderman Vaccaro.
Did you have a response to something before we go?
I did just somewhat. I mean, obviously, we're not talking about children, and obviously, you know, I just know I get a lot of complaints even about barking dogs. And again, I don't have an issue with urban gardening. We do that in our ward. I don't even have an issue with more chickens. I do think when you start talking about goats and sheep and other things like that, it starts to get to be a problem where I just see it as that where I get a lot of phone calls in the middle of the night telling me that, you know, I need to do something about. I get them already about other things, but they'll be calling me in the middle of the night telling me that this guy's goats make noises.
And I think there was some careful handling of that in here with regards to the size of the lots and things like that. So that those have been addressed. You know, you can't obviously keep a goat in a very, very small lot. And there were some, you know, I think there was some very careful consideration. I think folks advocating for this have really vetted this to what's happening in other cities. Because the last thing we want is to have a backlash against the urban farming movement. And so I think, you know.
Okay.
Just on that part, you know, is what the only reason I could not support it.
Sure.
You know, again, I have nothing, and it seems like it's going to have enough support anyway, but it's that's where I really have my issues.
Yeah.
After Alderman Green, you're next. We'll take some of the public testimony.
Great.
Alderwoman Green.
Just wanted to thank you for bringing this forward. I am a big proponent of urban gardening. I have a chicken coop and have not yet put chickens in it, so I'm excited to do so. And I would like to ask the clerk to add me as a co-sponsor, please.
Thanks.
Mr. Chair.
Yes.
May I inquire before we take public testimony?
If you can do a quick
one. Quick question. Okay. So on the livestock part of this bill, can I ask that we may look into licensing before it passes off the floor? Only because I remember when we went through the rooster issue, and you know we prohibited. That was probably my first or second year down here when the alderwoman from the 7th Ward at the time introduced that bill. And it became very difficult to administer because folks had already obviously had roosters, and just because we, you know, made them illegal, folks didn't have to get rid of the ones that were existing, but we didn't know which ones were existing at that point in time because they weren't licensed. And so I think it would be very helpful, you know, not only from a public health perspective, but you know, it is livestock, and so you know we should probably have some dogs have to get licensed in the city of St. Louis. I would imagine, you know, a goat or a sheep should also probably have to get licensed if we have to license dogs.
Sure, I'm amenable to that. I mean, to me, that seems
so, I mean, if we could
reasonable.
have that amendment ready for the floor, if we don't already have something like that, that would be great.
Sure.
Okay.
No,
For-
just
no,
the
just for
livestock category, which
goats,
is,
for goats and sheep, the livestock
Yeah.
portion of it.
We'll go to the public testimony at this
Great.
point. We will limit each, or please keep your comments to 3 minutes. We have a number of people that have signed up for it. I will do my best in trying to read some of the writing in terms of the names. We'll first take up Melissa Vatterott. Please, when you come up, identify yourself and
Sure will. Thank you for allowing me to speak today. My name is Melissa Vatterott. I'm with Missouri Coalition for the Environment. I didn't realize I was only going to have 3 minutes. I had some thoughts about the research that we did on the language. Mentioned, I just really quickly, if I could, there was a question about bees, and maybe I misheard it, but we do have in Title V, Division 9, Miscellaneous Offenses and Regulations, there is a section about beekeeping. Was there, if there was confusion, I just wanted to make sure you guys knew that that is in the city. And then we had thought about adding rat-tight birds because many cities across the country, that's a very common way of categorizing the list of options for birds. That's pretty much all I had about the language. So I just wanted to let you guys know I'm the Food and Farm Coordinator at Missouri Coalition for the Environment, and we're an environmental advocacy nonprofit. The reason why we care about food is because industrialized agriculture impacts everything that MCE works to protect: clean water, clean air, open spaces. We also work to fight climate change, and so we saw an opportunity to support a sustainable local food system within the St. Louis region. That's what I work to do, and I'm very excited to have been able to work with Alderman Ogilvie on this initiative. So I just wanted to let you know that we did gather broad-based support from people in the community for this bill, and in fact, in my role at MCE, I lead the St. Louis Food Policy Coalition, which was formalized in October of 2014, and we have stakeholders across multiple sectors that support urban agriculture, and this was one of the reason why we worked on this was because it was a top priority from all these different individuals we work with. I just want to share with you from an environmental standpoint why Missouri Coalition for the Environment supports this bill. Allowing more farm animals in the city will incentivize individuals to get outside and be exposed to the outdoors and nature, also be exposed to where their food comes from. There's also an opportunity to increase self-sufficiency of where your food comes from, food supply. With our industrialized agriculture system here in the United States, the average fruit and vegetable, I know we're here today to talk about animals, but travels 1,500 miles. So the idea of being able to provide some protein sources from eggs, potentially goat milk, here in the city would be useful by potentially lowering the environmental impact of the residents in the city. Also, chickens can add a benefit for the city to reduce pests because of the different insects that they will eat, and also green waste we can divert from landfills. There's also composting, of course, but farm animals will eat food waste, and that is a benefit for our environment by diverting that from our landfills. Lastly, from an animal welfare standpoint, the current law allows 4 total animals, including pets and chickens. So if you had 2 dogs and to be in compliance with the local ordinance, you could only have 2 chickens. But for ideal animal welfare purposes, it's best to not have any less than 4 chickens. So by the current law, I'm just saying, restricts the benefits for the animals, and it would be nice to see that residents could have more.
Okay.
That's all I have.
All right, thank you. Next we will have, I believe it's Joel Walker.
Good morning. I'll try to keep it brief.
Thank you.
My name is Joel Walker. I work with the International Institute Global Farms Program. We work primarily with refugees and immigrants in gardening, and most of the food that the new Americans, as we say, grow goes to their homes and their families for their own personal nutrition. One of the aspects of their self-sufficiency in terms of having fresh, locally produced food that they grow themselves is that they don't really have a high-quality protein source. Now, the chickens can add a very high-quality protein source, and however, two chickens will not really serve many of the very large families that we work with. We have families of up to 10. And so having increased number of chickens would be a huge advantage. We have many people who go to Illinois to purchase goat meat. And that, from the standpoint of them being able to grow their own meat here in St. Louis, it makes a lot of sense for them. They also would utilize the goat milk as an additional protein source. And we also, most of the folks we work with, they have traditions of farming that go multi-generational traditions of farming. They're professionals when they arrive here. They just need to learn, number one, the Missouri environment, but also the systems that we have in place here. And it's part of our job to teach them how to do that. We do have a gentleman who is was a professional trainer. He trained people in small animals, and he would be an excellent candidate for raising goats in the city. Now, the last thing I want to mention is that the goats eating all of the green trees and different things like that, there are many areas of the city, and I think that the city could benefit by a program that may actually allow goats to be tethered to clear off vacant lots, LRA land, and it could actually save the money for the city in the long run.
Okay. All right. Thank you. Thank you very much. Next is Scott, is it Krummacher?
Krummenacher. It's very...
Would you pronounce it again? What was the last?
It's Krummenacher.
Krummenacher, okay.
Yes. I'm a resident of Lindenwood Park, and my group of students were the students that were working in the research behind some of the bill. I'll just say this, because I can't speak competently about raising the animals or the sounds they make or any of that. I will say that what's allowed in the pending legislation is very reasonable when you look at other cities and what other cities allow. So for example, the chickens, most cities will allow anywhere in the range of 8 to 15. So we're nice at the lower end of that spectrum. Same is true for lot size and the restrictions there. We are at the lower end of that range. So very reasonable, and something that, again, we've looked at this very closely, and we found that St. Louis would fit pretty well within that range under the current legislation. So I support it, and I think it's going to be an improvement for urban agriculture in the city. Thanks.
Okay. Thank you. Next is Mary Olstaff? I'm way off on that. Okay.
Ostafy.
Ostafy?
Like ostrich.
Okay,
Ostafy.
sorry.
Good morning. My name is Mary Ostafy. I'm a resident of Ward 7 here. And last year, I transitioned out of my full-time professional career to do urban farming full-time. I built a rooftop farm just a few blocks away down the street called the Food Roof Farm. And since then, I have received dozens and dozens and dozens of inquiries from people in St. Louis, outside of St. Louis, whether they be students or professionals or just interested citizens in transitioning into urban farming. And I'll tell you what, there are a lot of other cities that are leading this cause right now, and those cities are going to be the ones to attract these people. We have tons of great students at our universities here interested in this profession, and they're going to go to the place where it's incentivized the most. I'm a huge advocate for this bill, and I really applaud the people that brought it forth to this committee. I hope it moves forward, and I hope that St. Louis can continue to be progressive when it comes to urban agriculture. Thank you.
Thank you. Next is Ryan Albritton.
My name is Ryan Albritton. I run a startup out of the Cortex district that aims to connect people around local food and build community around local food. I originally talked to Alderman Ogilvie about potentially addressing urban agriculture issues about a year ago, and that came from a clear desire from many people that I've talked to build up our potential for urban agriculture, whether that's community building, potential economic benefits from it, but it's clear that a lot of people want this, and like Mary just said, make St. Louis a better progressive place. So, thank you.
Thank you. Whitney Stovall? Sewell.
Yeah, Sewell.
Thank you.
Cool.
That's all right. They're correcting me up here. That's all right. Okay.
Thank you so much. I'm just going to echo a number of the points that were already made, but additionally, I'm here as a representative of St. Louis Language Immersion Schools, a director on the Greenhouse Venture, a project coming up in the Shaw neighborhood. It's a greenhouse, great educational opportunity combining 4 different types of schools and allowing for educational opportunities to be present in our standard education system. So currently, St. Louis Language Immersion School has 4 chickens, because that's the rule, and allowing for the children to participate in taking care of just the 4 chickens, even though we have an extensive facility for the chickens. Increasing that number would allow the kids to participate on a more hands-on basis instead of having to divvy up the work. But the product is also available. Each chicken lays 1 egg in a laying season, or daily on a laying schedule. So that's 4 kids that get to go home with 1 egg. But what if we're allowed to give the children more than that, more eggs for the kids, and help to increase the amount of protein that they're having access to? So a number of possibilities. I also want to just echo the survival rate of chickens. So normally, if we're looking to aim for about 4 to 6 chickens, you would start with 8 eggs and hope that you get 4 to 6 chickens out of that. If you get more surviving from that group, you want to keep them. And maybe some of them turn out to be roosters, and so you have to give those away. So increasing the number that we're allowed to keep, I think, is just allowing for this organic process to occur in the chicken keeping arena. So that's all. Thank you so much.
Thank you. Next, I believe, is Jamie Faith. Oh, that's not you. Okay. Annie Machi?
My name is Annie Machika.
Machika.
And I live in Benton Park West. I operate Urban Sprout Farm. It's an urban garden, and this will be our first year going to market. We have my property is 38,000 square feet, so it's 4 lots in my house, and so I'd qualify to be able to get a goat or a sheep. And it's not really something that I plan on doing anytime soon because it requires a lot of work. I'm not there yet, but it would allow me to do that in the future and maybe have more things to sell at market. I have chickens now, and I'd like to be able to get more so that, again, I could have more to take to market. And as far as having animals in the city, my neighbors are very supportive of what I do, and the kids walk by and they see the chickens out in the yard eating bugs, and people come up and ask me all sorts of questions about it. And so I think it's really good for the community, and I support this bill.
Okay, thank you. That completes our list. Alderman.
Looking at you, Alderman from the 20th.
She has an amendment.
I'd like to offer, Mr. Chairman, I'd like to offer an amendment. I think it should be being passed around. This is just a simple change that would exclude ostriches. That way our city health department doesn't have to obtain a special trailer to go chasing them down the street. I'd like to make them, I'd like to move that we...
Second.
It's been moved and seconded that we adopt amendment number 1 to Board Bill 296. Is there any discussion on the amendment? Or you want to further?
No, the only other question was regarding these emus, perhaps, or...
An ostrich is just the largest,
Sure.
Bird. An emu is big, but an ostrich is very big
and faster
and harder to contain. If they get out, they turn into velociraptors. So, an emu. I think there's probably more interest in eating emu eggs also. An ostrich egg, while you can eat them, is just like an enormous thing. Yeah, an emu egg's a little more manageable. So,
are there any questions or further discussion on amendment number 1 to Board Bill 296? Okay. Then if I was asking, do we? have any other further discussion on amendment number 1 to Board Bill 296? Okay. There's no other discussion. We will call the roll.
Alderman Bosley. Alderman French. Aye. Alderman Vaquero. Alderman Cone.
Aye.
Alderman Carter.
Aye.
Alderman Coder.
Aye.
Alderwoman Spencer.
Aye.
Alderwoman Green.
Aye.
Chairman Kennedy.
Aye.
We have 7 ayes and 1 no.
By your vote, you've passed amendment number 1 to Board Bill 296.
And the reason I did that,
If you wish to explain.
well, the reason I did that is if you do previous roll, then
Okay.
though I would have no objection to previous roll.
Are there any other amendments? Then we need a motion to adopt Board Bill 2, Committee Sub for Board Bill 296 as amended.
I'd like to move that we adopt Board Bill 296 as amended.
Second.
Previous roll.
Been moved and seconded.
Objection.
Been moved and seconded that we adopt Board Bill 296 as amended. Any discussion on the motion? I would just like to mention that certainly within my lifetime living here in the city of St. Louis, it was common to have chickens in North St. Louis as well. Chickens, raccoons, small pigs, raccoons, and a number of other items that were common that people had either in their basements or in their backyard as a way to feed themselves. And as it went on through the 70s and 80s, the city became more and more restricted and began to limit and outlaw the various animals. So this is not just a South St. Louis thing, but certainly for a number of individuals. I didn't see very many African Americans coming up here speaking on it, but I just wanted to put that historical perspective that this was common, particularly as African Americans were moving into the city out of the South and coming out of agricultural backgrounds. They continue to do those things in the backyards, growing food and having various kinds of livestock and animals as a way to feed themselves. This was not for sport or just to have a pet. These animals provided food for these individuals. And as we found out today, far more healthier than what we're oftentimes getting out of the grocery stores. So that's my lecture for today. We do have an objection to previous roll. Is there any further discussion on the motion? If not, unless you say it's not, it is. Yeah, do pass recommendation. With that then, Mr. Clerk, would you call the roll?
Alderman Bosley. Alderman French. Aye. Alderman Vaquero.
No.
Alderman Cone.
Aye.
Alderman Carter.
Aye.
Alderman Coter.
Aye.
Alderwoman Spencer.
Aye.
Alderwoman Green.
Aye.
Chairman Kennedy.
Aye.
We have 7 ayes and 1 no.
By your vote, we have passed out Board Bill 296 as amended with a due pass recommendation.
Thank you very much.
Thank you. We will now take up Board Bill 280. We'd like to thank you for your patience and those that you have here to speak today on the bill, on both sides of it.
Thank you, Mr. Chairman, members of the committee. Board Bill 280 is the affects the firefighters, the fireman retirement system, no, the firefighters retirement plan. A couple of years ago, the city transitioned from the fireman retirement system, FRS as some people know it as, to the FRP plan. Effective February the 1st, 2013 is when the new plan became effective. But as you might remember, it was litigated for probably about a year. And it went all up to the Supreme Court, and they basically said that the city of St. Louis could have its own plan for the firefighters. You might also remember that when the plan was put in place, you know, the firefighters in the city were pretty much at odds, so there was not a lot of negotiating back and forth about what this new plan could look like. And so they didn't have a lot of input in the plan. So for all practical purposes, the plan is still relatively new. What Board Bill 280 is going to do for us is help make the plan a qualified plan in accordance with the IRS code, so that they can enjoy the rights and privileges of other plans that are out there being deferred, tax being deferred, and so on and so forth. Certainly, I am not an expert in this field, so I made sure that I brought someone with me that's well-renowned, exceptional expert in this field, who works on behalf of the plan, not on behalf of the city of St. Louis, but on behalf of the pension plan. So the fiduciary responsibility is only to protect the plan and enhance the benefits of the plan. And her name is Mary Beth Braitman, but I also have, of course, from the City Council's office, Mike Garvin, Mallory Allen, and Janice, get Janice's name right, Janice Fairless, who's kind of like the administrator for the plan. And we also have John Costello, a firefighter, who's also the trustee chairman of the plan. What I'm going to do is have Miss Mary Beth come up and talk to you. There's a presentation. I see most people have it before them. I'm taking this very seriously. You know, I'm a very process-oriented person. I want to make sure all I's are dotted and T's are crossed, and people have the right information to make the right decisions that affects the city of St. Louis, and more specifically the firefighters' pension. So I'm going to have Miss Mary Beth come up and kind of walk you through the presentation. I am not asking for a vote today. There may be some other good information that come about, because we will bring a committee substitute next week before you, and it's based on some correspondence exchanges between the lawyers with the firefighters, Local 73, and Ice Miller, who's the official entity that Mary Beth works for. Okay, so again, I'm not asking for a vote, but I want to make sure this is a very informative meeting, and please ask her all the tough questions. I expect that representatives from Local 73 will come up and testify, and hopefully a lot of their anxieties will be calmed, and there's a lot of great dialogue about how we move forward, because what we don't want to do is not have a qualified plan and be headed toward disaster. So, Mary Beth.
Okay, thank you.
Mr. Chairman, members of the committee, it's a pleasure to be here to speak to you this morning on this important issue.
And thank you for your patience with us
well,
today.
that's quite all right. It was fascinating to hear some different subject matters as well. Not that I would ever think anything was as fascinating as the Internal Revenue Code, though, so we will be moving to that. So I wanted to just mention in terms of, just step back for a moment, this is a process in terms of getting plans qualified that has existed for quite some time. There are many reasons for it, perhaps most importantly from the Internal Revenue standpoint. This is the largest tax expenditure in terms of individual deductions, if you will, or shelter from income that exist under the federal code. It's far outstrips things like the home mortgage deduction. There are billions of dollars that are sheltered in these plans from current taxation. And accordingly, the IRS has set up a process for making sure that the plans that are taking advantages of these significant federal tax benefits, in fact, meet the fundamental requirements of what the label it's being used and has been used for decades as a qualified plan. And they have a process for doing this. It is a process which is in the midst of change, interestingly enough, but what it has been is that they would issue a determination letter. The IRS actually issues a letter to the plan upon application that says, you know, in the opinion of the Internal Revenue Service, this plan contains the requirements that it needs to be a qualified tax-exempt plan. It gives a tax exemption to the trust under one section of the Internal Revenue Code, and then as well, all the members' tax benefits go with that. We were brought in, as the Alderman noted, not to represent the city or not to represent the union. We were brought in to represent the plan and the plan's interest in the structure and the ordinance that goes with the plan. It was our assessment after looking at the plan ordinance that had passed earlier, when the new plan was created, that there were some things that we recommended be changed to, in many cases, and you'll see, we'll go through these, in some cases clarify a provision to make it, other cases to make a provision administrable and sync it up with the closed plan where that was the appropriate thing to do to avoid confusion from members and so on, and calculation of members' benefits who were perhaps in both plans at some point or had been a grandfathered participant in the plan. So with that, we did a review of the plan, we made our recommendations, and this is what is represented in the presentation and the points that I've included in this outline. The first thing, and this is on slide 3 of the presentation, is a change just to make sick leave conversions automatic without the right to request a cash payment. The members can elect to have unused sick days converted to years of service, final average compensation, an additional accumulation in their drop account. There are certain options which they can have within the code without creating taxation at the time they have the option. And so there were just a few changes necessary, we thought, to ensure that end result based on some 2009 revenue rulings. The second thing was to allow non-spouse beneficiaries to roll over, if they were entitled to a rollover from the plan, to an inherited IRA. This was something that was added recently by Congress to give a certain ability to roll over and protect the non-taxable status of dollars when you had a beneficiary that was not a spouse. So that allows that. There were some changes made to reflect current mortality tables for applying the Internal Revenue Service limits in the plan. Those mortality tables change occasionally, and we had recommended a change to the newest one. There were additional benefits passed by Congress for members of the military service, and there are several of these that you'll hear about in the course of this presentation. Our recommendations were simply to bring in each case the new plan up to date with the most recent federal benefits for people who were serving in the military service and then returning back to be a member of this plan or continuing as a member of this plan. Another such thing is differential wage payments that may be made for someone who's in the military also get included, so you don't end up, that's allowable now under federal law, and this lets that happen if differential payments are made to not limit the benefit of those differential payments for pension purposes. Number 6 talks about a direct rollover of after-tax amounts that are now allowed to be made and you might have after-tax dollars because of things like service purchases. Number.
There was just a quick.
Certainly.
One quick question just from your earlier statement. I was confused, so you're not being paid by the city or anybody else?
We're paid by the pension plan.
By the pension plan?
That's correct.
So that would be the firefighters that pay into it, so that would come out of that pension fund then? I was just confused by the statement.
Yes, the pension fund it's one of the pension fund bears a number of expenses for investing their dollars, expenses for administration of the fund, and expenses for legal work and actuarial work.
So that comes, so the firefighters, in a sense, I guess, are paying for your.
Well, of course, the fund is funded by both the city and the members of the firefighters union covered by this particular plan, but.
I was just I'm confused. So you said you're not representing the city or the firefighters.
That's correct.
In this, and I guess I was just curious. So if it's coming out of their pension, you're the one paying it then, right? I mean, they're the ones paying it?
Well, in effect, indirectly, since the city and the firefighters fund the pension system, are the two entities that fund the pension system, in that degree, they are funding the expenses of the pension system as well as the benefits payable under that pension system.
And the company you work for is?
Ice Miller.
Ice Miller.
It's a law firm.
It's a law firm.
Okay. Thank you. You can continue.
You're welcome. I think we were down to the number 9, which is there's certain post-tax compensation that now can be applied when you're applying the limits under the Internal Revenue Code, and that is a provision that you can add in again to make sure the limits don't adversely affect members in the plan. There's also some updates on the way that another code section relates to the limits on the plan. I won't go into all the detail here. There's an update in interest assumptions in applying the IRS limits, which we also updated. And then there are certain COLA adjustments under the IRS regulations, which we updated, as well as a mortality table. So some of these things are just a matter of picking up new IRS changes as time had passed. Yes, that'd be great.
Hello, I'm Janice. I work with the plan on a day-to-day basis. These were the other areas that we cleaned up administratively on slide 5. And the first one is just simple things like the fire chief's now called the fire commissioner in accordance with the new pay ordinance. So we're just trying to clean up these sort of details. The cost of living increase uses CPI, and it was specifically during preceding 12-month period as designated by the Board of Trustees. This allows consistency with the FRS, with the other plan, so when they give their people cost of living increases, we can use the same time period and match it. The drop accounts are now called accumulations instead of accounts, and that was Mary Beth's recommendation because we're really not like a bank account. It's an accumulation. The no reduction on early retirements under 55 with more than 20 years service as of the effective date. On number 4 and number 8, we talk about that, but there were several places in the plan where when you start paying benefits, it doesn't repeat. It'll say no refund of contributions, but we know it was for the firefighters that were grandfathered in that had 20 years prior to 2/1, that they were entitled to a refund of contributions. So we've asked them to reiterate it in different places in the plan. So there's never a question if we look at it again. Grandfathered members, their contributions remain at 8% when they come out of drop. That was something we've already done a resolution on, but it was a typo in the plan, so we corrected that. In the plan, it opens the door to allow ad hoc COLAs as if the plan had them. The other plan has ad hoc COLAs for when you run out of COLAs after your 25% COLAs. This just allows ad hocs. Presumption language now references pension law. In the original plan, it just mentioned disability caused by a lung disease. Well, it's the heart-lung is the state statute, and so we referenced that. We went into that and used that, tried to get closer to that language. Number 8 is still on the 20-year service. Number 9, the widow pay during the widowhood, not lifetime. The plan is, it states they get 25% if a firefighter dies. Their wife automatically gets 25%, and that's paid during their widowhood. Then the very next sentence says, and they may apply to be a contractor or consultant for the city and get another, or for the plan, and get another 25% to be paid during their lifetime. So we had the discrepancy where it was written lifetime one place, widowhood second place, or widowhood first place, lifetime second. So we wanted it to agree. Widowhood is currently what the FRS does. And so we were keeping with that was the intent of this language, and we just tried to clean that up. And you can't get the one without the other. First you apply for you automatically get the 25%. This was on the second 25%. Funeral expense, we recently had to pay one of these, and it goes to a beneficiary. In case they don't list, they need to list a beneficiary so we know who to pay it to instead of multiple family members coming in saying, I want this money, I want this money. So it was just trying to clarify that. Allows retroactive payment of benefits, and And today, a lot of times they have to, they have to apply on both sides, but they may go down to the FRS today and apply, and I have one guy down there right now going at the FRS, but since I'm here, he's not coming to see me till tomorrow. So if he says his retirement day's one day on one side and the other day on the other side, it doesn't work. So we're just trying to make it consistent so we can, and then the board has to approve their pension. And their retirement date's today, but we have to wait till the next board meeting to approve it. So that's the reason for the retroactive language. Bring a driver's license in. The original thing said bring a birth certificate in, and people don't have that in their pocket, but they do their driver's license, and they're pretty tough to get these days, so we ask them to change that. The comptroller asked us if we could just put a designee in case, because every board, it either said the comptroller or deputy comptroller, and the deputy comptroller was running out of time slots to go to meetings, so they asked if a designee could be available. And then the board shall be authorized to modify or amend the plan without legislative approval. That was only meant to be when necessary, for when there's a qualification issue that the IRS comes down and says, hey, you need to be doing this way. So we would be able to change it administratively, and then we take it to the board to say, hey, this is what the IRS says we have to do, and we have a time constraint to change it. That was the only intention on that change there. So those were just some changes that we reflected there. And then on the next page, we look at what are the other cleanup items that are in the bill. This next one is one of the biggest ones, and it actually gives the firefighters quite a bit. The interest rates for their drop accounts, currently the plan says they get plus or minus whatever the investments do. This year, it was minus 4%. So the firefighter that has $5,000 in his drop just lost $200. But what this is going to do is amend it to say interest rate plus or down to 0, or they get a choice of the 10-year T-bill rate. So it would give them an option on interest rates. I know at the FRS they have 4 options, but our plan only had the one in the original language, where it had, you only got the plus or minus based on the plan performance. So this is just a huge thing, because you can get all the benefit without absorbing a big negative year, which you will see on and off in the market. The next one is here, language added for purchase and transfer of creditable service. And so far, we've had over 40 firefighters apply they've asked me to research what will it cost them so they can buy service. And that's a new feature this plan didn't have originally, and so we're putting it in the ordinance. And then tuition, I'm going to pass it back to Mary Beth. She's more the expert on the tuition.
The tuition assistance program was not in the old closed plan. It was added in the new plan. And this is an instance of where I had raised the issue that this was not that tuition assistance plans weren't perfectly fine. The issue that I raised was that they couldn't be paid out of pension fund assets. They could be paid out of any other kind of assets that were available, but not the pension plan assets. And the reason for that is that the IRS has a very fundamental rule for decades that a pension plan needed to provide for definitely determinable pensions, generally payable for lifetime on account of retirement, disability, or death. And this again, not judging whatsoever about the merits of this particular benefit, but just looking at the source of the payment of this, I didn't see that it would be permitted under a number of IRS regulations. And so I had recommended that this not be paid out of pension plan assets. Again, it's beyond my purview to know where beyond would take one, but just with pension plan assets. So that was a change that I had recommended for that reason. I wanted to, on slide 7 or 8, excuse me, I wanted to talk just briefly about the importance of being a qualified retirement plan. The first and perhaps the foremost is the tax status. Members don't pay taxes on contributions to the plan, their own contributions, or the contributions that the city makes to the plan until they're taxed on benefits only as they receive them, and that obviously in some cases is going to be 25 years from now when they retire from the firefighter force. Employer and plan participants also don't pay employment taxes when contributions are made to the plan or when benefits are paid. So these dollars are not Social Security covered dollars or subject to the FICA and the OASDI taxes. Rollover options are important in terms of the drop accounts particularly. Benefits that are distributed from this plan in a lump sum, such as refunds and drops, most importantly, those two items. You can make tax deferred or Roth rollovers of eligible distributions to a number of other plans, and that can occur when you terminate employment, when you retire and take your drop account out, and so on. So that's a very significant benefit to the members. Employee contributions are all before tax in this particular plan, so it reduces a participant's taxable income each year as they make their share of the contributions. This plan also currently can have investments available only for tax-qualified plans that are constructed by the investment money managers. If the technical corrections bill doesn't sync up on these matters, in some cases, it would revert either to a no benefit, such as some of the things that Janice talked about, where it wouldn't sync up with the COLAs, it wouldn't take the put the minimum floor on the interest crediting. So there's things, basically everything she and I had talked about before would not occur. I think that the position, if this plan's not qualified, is that the rollovers go away in their entirety. The special investment opportunities would go away. There's no tax deferred compensation, no pre-tax contributions on the part of the firefighters. And the worst thing that can happen if you lose the qualified status of the plan is that then it all becomes a non-qualified deferred comp plan, which means that contributions would be taxed as they're paid in, and you'd have or you'd have possible tax IRS fines for violations. And I know that the pension system added to the last slide 10. I'll just go over it quickly because I know sometimes there's well, would the IRS really do this? Why would they hurt, the city of St. Louis and the firefighters, for goodness sakes? And it is because it is their charge to make sure that these plans meet the various qualifications, but they do in fact do it. And there is an instance here in the settlement of the employees' retirement system, an application and a correction that needed to be made where there was ultimately a $40,000 penalty assessed against that, so to pay for that correction. So yes, the IRS does really care about these plans, and yes, they do in fact follow up on them. So with that, I'd certainly be available to answer questions or Mr. Chairman.
Questions from members of the committee? Alderman French?
Sure. So many. Good morning. How are you? All right. It's not morning anymore. So one, I want to get some clarification. So you represent the pension board?
Pension board, pension plan.
Okay. So the pension board hired. Okay, you represent them. All right. I also wanted to kind of, and this isn't really towards you, I think some earlier statements were given about the history of how we came to this. I remember this very clearly. The original bill that changed the fireman pension plan set up a single new plan that put all firemen under that plan. The chairman at the time was Chairman Carter. And he set up he had both sides come and sit down at the table. He had sent me as a representative of the committee. And at the time, the firemen, I remember, suggested setting up a two-tier plan, that the existing firefighters who had been promised benefits would be in that continuing plan, and new firefighters would be in a new plan. The administration rejected that, wanted everybody under this brand new plan. Eventually that passed the Board of Aldermen and was sent to court. The judge issued some guidance as he was deciding the case to suggest that certain things should be changed. Several bills came back at the Board of Aldermen changing it and setting up a second tier. After we passed that and that became law, ultimately the judge said, fine, the new thing is legal. But let's be clear, the first thing was illegal. The first thing that was attempted was illegal. And I think that's important because I think when we make a promise to employees and they agree to serve for many years for certain compensation, including the pension package, that I am not comfortable with coming back and then changing that halfway through and breaking that promise. So there's some things in here that that you went through in your presentation that I have some questions about. The first one is on page 5. The areas that are listed under other cleanup areas. There are quite a few things in there. Funeral expenses goes to the beneficiary. Widow paid during the widowhood, not the lifetime. That's a significant change. But the one that mostly drew my attention was the very last provision there. It says the board shall be authorized to modify or amend the plan without legislative approval when necessary to maintain the qualified status of the plan.
Can you, he needs to change the tape. Can you open that?
Oh, okay. So, section 14 there on page 5 says the board shall be authorized to modify or amend the plan without legislative approval when necessary to maintain the qualified status of the plan. So that says that the pension board would be able to come back and make any changes without having to come before this Board of Aldermen. Am I reading that correctly?
Well, this is one, and perhaps I should defer to Mr. Galvin. This is one that we've added some language in the newest draft of this particular thing in response to a concern raised by the local attorney to make this much clearer. I had recommended a change, but I had wanted it to be clearly only in terms of a technical or administrative amendment that the IRS had raised, so that as a matter of convenience. But that was not clear, as was pointed out in that language. And so there is and I don't know if you want to explain exactly where this is in terms of but we added a change to hopefully respond to that concern.
Okay.
Yeah, we did receive some comments from an attorney for Local 73, and we were going to clarify that these are only administrative or technical changes that will be authorized under this section. Like if the IRS says you must send whatever they want in order to get qualification, we can do it without having a new ordinance passed allowing them to do it. That was the intent here, so we're prepared to insert the words technical or administrative or something like that would limit the scope of that provision.
Mm-hmm.
And it would require board approval. It wouldn't just be a unilateral thing.
Mm-hmm. So as written now, though, this could, in effect, again, as written down before your amendment, this could be the last time this board ever deals with pension issues.
No, it's only on issues that affect IRS qualification.
In the amendment that you plan to offer, or the draft?
Oh, it's actually the way it's worded now.
So where is that?
Do you have the code, the original page 64?
In the, okay.
What that is the current code section, which is actually two ordinances combined in the code in chapter 419. That's toward the top of the page.
What code? So I'm looking at page 64, lines 5 through 7.
Right.
It still reads, the Board of Trustees shall be authorized to modify or amend the plan without legislative approval when necessary to maintain the qualified status of the plan pursuant to IRS requirements.
Right, and I was saying we're prepared to add in the technical or administrative terms into this provision, but in your last question, you said that it just gives carte blanche to make all changes. It specifically says now to maintain the qualified status of the plan pursuant to IRS requirements. So the only changes it allows, even without the technical language, is changes that are required by the IRS.
Yeah, so, for instance, page 7 of the presentation, the argument is being made that doing away with the tuition assistance portion of the pension plan is being suggested to maintain IRS status.
Correct.
That's a pretty big deal, though.
Well, in substance, I don't think it is, but I understand why there's concern about it, and that was done on the advice of the tax counsel, so she's the best one to address that. But I don't think there's any serious disagreement among any tax counsel on that point. I think they all agree that it needs to come out. If you want more on that, she's the
Yeah, well, so about that,
And I think as well, just to follow up one point, that would be differentiated with that new phrase, making technical or administrative amendments. This change would not have come in under that rule.
I haven't seen that language yet, the new proposed language, but in the language I'm looking at now, that they would.
Right.
And I think that's one of those things that, most people wouldn't know that that benefit could be changed because of IRS implications. And so there may be other things that could be changed because of IRS implications I wouldn't know about. But instead of taking the thing out, it's the reason you give here is that tuition cannot be paid by a retirement fund since it is not a definitely determinable pension benefit. Instead of taking it completely out, can it be made a definitely determinable benefit? That is to say that all tuition wouldn't be paid, but it would be a benefit of a certain amount paid toward tuition?
The problem is that it needs to be to provide for retirement, death, or disability benefits as well. And the regulations have phrases like "and for lifetimes of participants," and so there's some different phrases that are used in the series of regulations that keep making this point kind of over and over from different angles. I think that the fundamental issue here is really that it's not a benefit that is structured to be something that you are entitled to if you hit these certain metrics. You hit an age and a service, for example, on the pension benefit. You hit a line of duty catastrophe for a line of duty disability benefit, for example, and of course death benefit requirements. This is structured to pay right now kind of an undefined amount of service of dollars to pay the tuition at a university should you choose to go to a university. It's very it's not determinable in several different ways. So the amount is not, you wouldn't know when you, part of the idea with these plans is you as a participant are supposed to be able to know if this happens to me, this is going to be the result. If I get catastrophically injured in the line of duty, this is the benefit that I would be entitled to. If I die in the line of duty, this is what my survivors will be entitled to. At each point, it's supposed to be predictable and knowable, and these are important benefits, significant benefits, which are being afforded to the firefighters pursuant to the bargaining agreements and pursuant to the Internal Revenue Code rules. This benefit is just not that, and I think it could be totally restructured to be an additional monthly benefit that if was paid if you were entitled to a particular disability, but it would simply just be an additional benefit that you knew you were going to get if you met these disability criteria.
And I agree with that. There's certain things that, you know, we want to provide some insurance so that folks know that they can count on this benefit. So with that in mind, these changes that you're talking about making, would they affect current members of the plan or future members of the plan?
Now, to date, we did check this. There are no members that have applied for this particular benefit.
Not
date,
that
so-
particular benefit.
Oh,
I
I'm
mean
sorry.
all the changes here. Will they affect current members or future members?
They would affect both.
Okay. So isn't that an example, though, of how, you know, people today have expected a certain benefit, and now we are changing it, and they won't get that benefit anymore? Not just with the tuition, but with all these things.
Well, actually, virtually all of these it's an improvement. It's an improvement to have the zero minimum on the drop account credits.
Well, for instance, number 9, widow being paid during widowhood, not lifetime, that is a reduction in benefit.
Well,
I'm not saying it's not
yeah,
logical or
and
fair, but it is a reduction
I think it's a
in benefit.
clarification because, and I'll let Janice address what was done and what is being done in the FRS, for example.
Well, we had one widow, and we told her it was payable during her widowhood when she came in and applied, because that's what the first part of the phraseology says. It says you get this 25% during your widowhood. And then the other, she had to apply for an extra 25% that the board would approve, which I gave her the application for that. I said, hey, you want to get this other 25% as well, so apply for this. But at the time, we just said it was widowhood, and she was fine with it.
So you say currently it is referred to two different ways in the plan. Where is the second way it's referred to? The one that actually suggests that it's for lifetime? In the plan somewhere?
Let's see, do we have?
Here's the whole section.
On page 35.
And it's 35 of the whole ordinance.
Okay. What line?
Okay, at the very top here where it talks about death benefits, it says line 7, provided no other benefits, there should be paid retirement allowance to the widow of the participant during her or his widowhood of 25% of the deceased participant's average final compensation, or $200 a month, whichever is greater, plus 10% of such compensation to or for the benefit of each unmarried dependent child. And then if you go down to line 14, it says any widower who is receiving retirement benefits upon application to the Board of Trustees shall be made, constituted, appointed, and employed by the board as a special consultant on the problems of retirement, aging, and other state matters. And that's where it said for the remainder of her lifetime. And upon the board, request of the board, give opinions and be available. And may required to be do so forever. Do so, you know.
Well, for the remainder of her life is pretty clear.
It piggybacks on the other. I can't. The first one, you get the first one, and then this is the second one you ask for, the second 25%.
I mean, I think a widow would argue that for the remainder of her life means the remainder of her life right now until we change it.
It's confusing because it talks
Right.
about the widow.
And that's why I brought it up. I said there was an inconsistency here. As the administrator, I said, hey, we've got to get this cleared up. Because it says one thing in one place and the next sentence down it says something different. My biggest concern is that since it does in the second half here, it says the board would have to approve the second 25%. I don't want the board not approving the second 25% because it's for somebody's lifetime. So I kind of had a fear of that, and that's why we wanted to clear it up and get it one way or the other. Because you don't want somebody losing this 25% for life because they might marry after 10 years. Somebody thinking, well, I got to pay this 25 for life. And the board might say, well, we're not going to pay 25 for life if she remarries. And I did check with the FRS. I said, can you clarify how you pay widows right now? And it is for their widowhood. It's not, when they remarry, they lose the benefit. So it was the standing plan how they did it.
So were the firefighters, or the union, or the widows, or the members of the current plan consulted or included in this redrafting of the pension language?
I know a letter, they were given it.
After it was done?
After it was done. They were shown the changes and asked for their input on it. And they did supply some, and then there was some correspondence back and forth.
But they weren't included in the drafting of the language or the changes?
Well, the drafting was a lot based on Mary Beth, and the other was for our administrative cleanup.
Okay.
So we have to tell them what we need to make it easier to administer it.
Okay, thank you.
Alderman Coder?
No questions right now, Mr. Chairman.
Alderman Spencer?
Thank you, Mr. Chairman. I assume we're going to hear from the firefighters union today?
Yes.
Okay, because I again would echo some of the questions put forth by Alderman French, and then just like to hear a little bit more. You know, in the opening, Alderman Boyd mentioned how there was not a lot of negotiation last time around with the firefighters union, how important those conversations are, and I think that's an important piece to make sure that we're all on the same page.
Alderwoman Green?
I'd like to hear from the union before I...
Oh, before you make, okay. Thank you. Did you have anyone else, Alderman? Okay, then. Then let's bring up, you want to come up and you make your statements first? Mm-hmm.
Thank you, Mr. Chairman, members of the committee. My name is Demetrius Alfred, also known as Al. I'm president of Local 73, representing St. Louis City firefighters, EMS, and dispatchers. And I appreciate the opportunity to talk before you today. To my left is our attorney. Her name is Kara Krawczyk, and she works for Greenfielders attorney firm. I'm going to let her open up with some of our concerns, and then I'll try to finish up and answer some questions. Is that okay?
That's fine.
All right, Kara, there you are.
Chairman and members of the board, thank you for giving me the opportunity to speak. Like Al said, I'm an attorney with Greensfelder, Hemker, and Gale, a law firm here in town, and I represent the International Association of Firefighters Local 73 with respect to Board Bill 280. Now, the city has submitted Board Bill 280 as necessary in order to correct some Scrivener's errors or typographical errors that they may have, and in order to maintain FRP's tax qualified status. But as I will discuss in a moment, in actuality, it's a bill with benefit reductions, like you've pointed out, and ambiguities that will harm firefighters in the future. While Local 73 does not oppose FRP retaining its tax qualified status and obtaining a determination letter to that effect, it's important to remember that FRP has already submitted its determination letter application with the IRS. FRP is going to have an opportunity to fix any qualification errors identified as part of the determination letter process during what is known as the remedial amendment period. And they can do those amendments retroactively if it's determined to be a qualification error. And as such, we don't feel that there's any need to rush in passing Board Bill 280. Also, it's important to remember that all of these IRS requirements were already in existence at the time that the original FRP ordinances were passed, and so this isn't anything new. So on behalf of Local 73, I oppose the passage of the board bill as it's written and request that you keep it from passing out of committee. With respect to the specific issues that we have, one is with respect to Section 5, and that gives the ability of the board to change mortality table and interest rates prospectively for determining actuarial equivalence. And it's the opinion of this firm that in order to be, that it may present a qualification issue in and of itself. Like Mary Beth stated, you have to have definitely determinable benefits in order to be a qualified plan. And under Section 401A25 of the Internal Revenue Code, a defined benefit plan shall not be treated as providing definitely determinable benefits unless when benefits are determined on the basis of actuarial assumptions, unless such assumptions are specified in the plan in a way that precludes employer discretion. And there's IRS guidance out there that states that the employer discretion includes discretion of the employer, plan administrator, fiduciary, and actuary. The trustees are fiduciaries of the plan, and therefore giving them the discretion to change actuarial assumptions we feel could be a qualification error. And I know in the proposed changes that Mike sent over last night, they stated that it would be on the basis of the actuary's recommendation, but again, under that guidance, it still doesn't meet the requirements of precluding employer discretion. One of the main issues we have with the board bill is the benefit reduction of the elimination of the tuition reimbursement program. Currently, 419.070 provides for a decreased disability benefit that starts at 25% of compensation for a firefighter that's unable to perform his duties as a firefighter, but does not render him or her unable to perform any gainful employment. However, that is offset by a tuition reimbursement program. Section 24 removes that tuition reimbursement program while keeping the disability benefit at that decreased level. And the reasoning is that it's a qualification issue. However, like I said, the plan has already been submitted for a determination letter based on what is currently in the ordinance. There's a lack of existing guidance as to whether or not this tuition reimbursement provision does in fact present a qualification issue, and therefore it would be our recommendation to leave the provision intact unless and until the IRS tells you that it's determined a qualification issue, and then you can fix it during the remedial amendment period. The other point to make is that Ice Miller through Mary Beth has stated that it could be done outside of the pension plan. However, there's been no offer to Local 73 in the form of a board bill to create this benefit outside of the pension plan or look at different alternatives to different alternatives than what's currently in the plan. Instead, they're just choosing to strike it altogether without trying to come up with any alternative solution. Also, Section 25, the city characterizes as a clarification that the widower shall be paid a widow's benefit over the period of her widowhood. However, the current plan states that for that special advisor's benefit that it will be over the period of the remainder of her life. So we feel that this is a benefit reduction and not simply a clarification. And the issue is not necessarily what FRS does, it's what is in this plan and what benefit changes are going to be made. And so we don't think that what FRS does is necessarily relevant. We also have some issues with the discretion that's given to the Board of Trustees. Specifically in Section 40, it gives the Board of Trustees the authority to amend the plan without legislative approval to maintain the qualified status of the plan. And this would give the board the authority to amend basically the ordinance without Board of Aldermen approval. The city states that this is a qualification issue. However, there's no Internal Revenue Code requirement that gives legislative authority to the Board of Trustees, nor do we believe that it's permissible to delegate this legislative authority to such a board. Also, there additional language that only administrative and technical changes can be made could definitely be a benefit reduction as demonstrated by the tuition reimbursement program, or even the widow's benefit. Also, Section 38 gives the Board of Trustees the ability to cancel, reduce, correct, and or adjust the benefits of any person who shall make any false statement or shall falsify or permit to be falsified any record or records. Cancellation of the benefit for any false statement we believe is overly broad and onerous, because under this language, anyone who has a mistake of fact when they're applying for their benefit could have their benefit canceled because they made a false statement. Also, Section 23 gives the board the ability to determine the preceding 12-month period in which the Consumer Price Index is based to determine the ad hoc COLA benefit. Currently, the plan utilizes the CPI for the previous calendar year, giving the board the discretion to change the period for which CPI is measured could have an effect in increase or decrease benefit levels. And so, therefore, we think that that's too much discretion. Also, the Section 14, it appears to give the board the discretion to determine which felonies bar participants from obtaining benefits. We don't feel that that's necessary because under the statute 105-669, it already specifies which felonies it applies to. So we think there's several provisions in here that not only decrease benefits but also give too much discretion to the board, and therefore we would respectfully request that you delay passage of this board bill and give Local 73 time to negotiate with the City of St. Louis.
You had some other remarks. Thank you.
Well, not really. I mean, I think she said it eloquently. I just wanted to add that our whole deal here today is, like I said, is to ask you guys not to take a vote and give us an opportunity to at least meet with the city attorneys, and let's try to have some more input on this, because we realize what a qualification letter would do for FRP, and we agree with that. We'd like them to be qualified, just not this board bill, we believe, makes certain changes under the disguise of applying for qualification that harm our members. So we'd like to take the opportunity to sit down with them and let's go over the intent, if you will, and if the intent is what it's meant to be, then let's change the language so we all understand it and do the right thing. So we just like the opportunity to at least talk to them and negotiate.
And you are aware that the sponsor has not asked for a vote today also?
Yes, sir. I heard them open up with that, and I do appreciate that. I know Jeffrey Boyd very well.
Let's go back through our list on questions from members of the committee, if any. Alderman French, any for them? Alderman Coulter?
No question.
No question for them?
Excuse me. Thank you.
Alderwoman Spencer?
Thank you, Mr. Chairman. So, has there been a has there been communication with Local 73 on this? And
yes. Yes.
And so, but there has not been an agreement to this point.
Well, not a negotiation either. There's been, when you say communication, it was brought to our attention in December that they were going to apply for qualification.
Okay.
And that it had to be applied for by January 29th.
Okay.
And that a board bill was coming forth, and some changes were having to be made to be qualified. And once I got it and started working on it and started looking at it, I had to contact an attorney. Or actually, I contacted a couple of attorneys, somebody that could understand it. But the way I read it, some things that were being changed for qualification took away some benefits that I assumed we would have an opportunity to negotiate. You know, if you take something away, maybe you'll get something back. And then other things were changed that didn't seem to affect qualifications that I was like, I think we need to talk about that too. So there's been communication. I don't think there's been a real opportunity to sit down and negotiate or, you know, have the input to change it. Recently, I did send them some information after talking to the attorney, and she gave us a lot of input, and I sent them the letter and say, hey, these are our concerns. And there's been communication with that. Let me just end with that.
Okay. And then I think this is maybe a question for the attorney, but so, and this is my non-familiarity with how IRS plans go. So the current plan does not qualify according to the IRS. Is that correct?
Well,
and
it operates
as a qualified plan. Excuse me.
It operates as a qualified plan until someone tells you that it's not qualified. You're in applying for the determination letter, you're just simply asking the IRS to confirm that, and you're setting forth that it is a qualified plan. So to say that it's not qualified right now wouldn't necessarily be true.
I understand. So that so it's not as though the IRS has come back and said these are the specific things that would prohibit it from becoming a qualified plan, but rather we're surmising what might be an issue with obtaining that determination letter.
Exactly.
Okay.
Yeah, as part of the determination letter process, they can come back and tell you these are the specific things you need to change, but they haven't done that yet.
And so if in the application process for that determination letter, we would apply for, you said the application was due on January 29th, is that correct? And so we submitted that application?
Yes, it's our understanding that it's been submitted.
And so if it's been submitted, I'm perhaps maybe just a little bit confused as to why we're changing it now after we've already submitted the plan as it stands, understanding that the IRS will probably come back to us with a list of issues, and perhaps, am I misunderstanding this? Okay, so it's my understanding we've submitted an application for a letter of determination, and then we are awaiting the response from the IRS to tell us what may be issues with our plan to becoming a qualified plan. And I'm just confused as to why we would make changes now before hearing back from the IRS on that.
If you could step up to the microphone to respond.
The submission, you get an opportunity when you're submitting a determination letter request such as this to make, to also make voluntary corrections to the plan that you anticipate may be a problem. It carries a very modest fee, $325. And we did that. We said that certain of these things would be changed, and those changes that we said we would be proposing to have made included the floor on the zero, no less than zero, because some of these issues have had an enormous amount of IRS activity in the last couple of years. This was one. If you didn't have something that kept the drop accounts as
From going
defined
negative.
benefit accounts, the IRS had said you have to apply the 415C limits. And I know this may be, I hate speaking in code sections, but it's a limit which would say that you couldn't credit more than $53,000 a year into the drop account. Well, some of the pension benefits are in excess of $53,000. And so we thought that we had to do something to say we weren't going to get into that whole fuss with the IRS that we've spent so much time on with respect to other clients. We just didn't want to get this plan in the middle of that, because if you put the floor of zero, then they say, no, it's a defined benefit plan, so it works just fine. And I know this sounds, I'm sure, archaic, but and it somewhat is. So we had prepared things, a series of amendments, and we submitted it on a proposed basis, saying these are the ones that we would bring forward and propose for amendment here. And the idea being that if the IRS accepted those, that we wouldn't have any sort of a significant correction we were going to have to make. It was all going to be done during this determination letter process, because we were all within this remedial amendment period. So we had put in the submission really virtually all of these changes in their earlier format before we made some of the most recent changes. So it is pending with the service now.
So it's my understanding that we submitted an application for the determination letter, and following that, we also submitted a letter outlining the changes that we were committing to the IRS that we were going to make.
Wait a minute.
Wait a
minute. Yeah. Board Bill 280 was submitted as part of the application. What you have before you was submitted as part of the application. That maybe that'll help clear you up a little bit.
Back in January?
Yes.
Okay. And so, from what you were just saying, at the time, you apply for a letter of determination, and during a certain period, and maybe you can outline that period, we're given the opportunity to voluntarily change things in the plan to make the likelihood that we get the determination letter higher.
That's exactly
right. And address issues that we anticipate being qualifying issues.
Yes,
that's a
better explanation than I gave. Yes.
Okay, so we submitted a list of changes that we've sort of committed to the IRS that we are going to make.
That we would propose to make, yes.
Sure.
We'd be proposing, yes, we are.
I think it would be helpful then if we could clarify which of these are changes that we have somewhat committed to the IRS prior to communication with the board that we're going to make, And if they're, because the tuition reimbursement, for example, I don't think would fall under that category. It does fall under that category? So the IRS would have a problem?
If we have left tuition in there.
How strong of a commitment have we made to the IRS that we're going to make these changes without?
Well, what we've done is we've submitted it as a proposed amendment. It's clear that it does have to go through legislative process.
Okay, thank you.
Thank you.
May I comment on this?
Surely, come right on.
One of the reasons that we submitted the voluntary corrections was back in 2002 ERS, they applied for a determination letter. And the IRS came back to them and said, in 2005, here's a closing letter. You have to fix all this stuff related to drop, but we're charging you $80,000 to do it. So our hope was to avoid a big fine to the city. And in 2005, they were able to negotiate that fine down to $40,000. But they called it a closing agreement as opposed to a fine. So that's why we went out on our search and got one of the best tax counsels in the country to give us good tax advice. So we could get the best plan forward to the IRS with the corrections, voluntary corrections that they felt were essential to avoid them coming back saying, okay, here's your letter back, but you need to change all this, and you're fined this, this, and this for having this in there. And you've paid this, this, and this. So.
And then to Alderman French's earlier questions regarding the sort of carte blanche on making changes, do we anticipate the IRS to make lots of changes in the future? Is this something that the IRS regularly changes the guidelines on this, on these qualifications on these plans?
Well, let's see. Let me answer that in two pieces, if I could. We don't expect them to come back with a lot more changes to what was submitted in January. We think that we would anticipate very minor questions that they would have on the application at this point. And I think you asked a question that kind of went to timing earlier that didn't get addressed. Right now, they're working with, we keep a tracker list for all the applications we have pending at the service at all the time. And right now, they're working submissions that they tend to work them generally in the order submitted. Mm-hmm. And they're right now working the submissions that came in February, March, April of 15. So we're probably about, and it can speed up a little bit or, whatever, depending on exactly how many applications came in each month. But I think we're probably somewhere around 6 months from getting an agent assigned to the case. And then the agent then goes through everything that was submitted and then comes back with questions, comments, and so on. So I think I would say that we're probably about 6 months interval from that occurring.
And I think my question, maybe it wasn't very clear. So I guess my question really is, do we anticipate, so with this, we've, to number 14 on page 5, authorizing the pension board to modify or amend the plan without legislative approval when necessary to maintain the qualified status of the plan. The question is, do we anticipate the IRS to be making all sorts of changes in the future that this is a necessary? They change these qualifications on a very regular basis at the IRS?
On that point, in terms of general, what changes, there's two things that change. There's basically two ways that changes get made to the requirements. First is Congress. And Congress, as you saw when we went through the list, Congress has a habit of changing something to do with these qualified plans somewhat frequently, whether it's enhancing rollover rights, adding Roth rollovers, whether it's, and then sometimes Congress, they've made all these changes over the years on the military service. So there's a series of changes that we noted were contained in our amendment that just Congress keeps finding some things they want to tweak in this. Generally not wholesale, enormous changes, but they constantly come up with changes. So that's one way that the requirements get changed. The other way that requirements get changed is via the regulatory process, the guidance process from the Internal Revenue Service and Treasury Department. And they have been quite active in recent years on changes to government that affect governmental plans. And they just issued about 2 or 3 weeks ago a whole series of normal retirement regulations for qualified plans and government plans, so particularly. So there is, it is an ongoing activity. It's not every year necessarily, but it turns out being just about every year there's something. Either Congress want it changed or that the IRS has followed up something.
Okay, thank you for that. And my final question kind of takes a step back, and when we introduced this plan, it was a fairly disruptive process. It was a huge overhaul of the firefighters' pension plan. And my question is, why didn't we? So if we're self-identifying these issues with the pension plan right now, as we're submitting that application for the letter of determination, why is it that at the time we introduced this giantly disruptive change to the firefighters' pension, we didn't self-identify these issues from the very beginning?
I was not involved in that period, so I'll move to.
Yeah.
So are you saying, why didn't we do our due diligence when the original bill for the plan was enacted?
Yes.
Okay. Well, from what I remember, like you said, it was very contentious.
And I wasn't here,
There
so
was
please
there
forgive
was
me.
not enough. I actually voted against it because I felt that there was not enough dialogue between the firefighters and the board and the city.
Sure.
But it was just a constant struggle. I'm not giving in, I'm not giving in, and the city had to act. And so the city ended up enacting this against the wishes of the firefighters. And of course, we ended up in court. Now it is what it is. But the city never moved on making sure that it's a qualified plan. A bill was introduced about a year ago, but no one was really interested in carrying the bill and doing anything with it.
And what was the bill for?
The cleanup, the technical corrections and everything. But, because no one wants to fight with the firefighters. No one wants to fight with the police. And shouldn't be about fighting. But anytime you want to change a plan, since I've been here, it tends to end up being a fight.
Sure.
No one wants to give up a benefit. And I get that. No one wants to have their pay reduced. And I get that. But at some point, we come to a situation where it's business or government that you have to make cuts. And you have to, reduce benefits if you want to stay in business. I mean, we can keep giving raises and we can keep making people feel good until we're not existing anymore because we can't afford it.
Sure. So, and I guess my point or my observation is that when renegotiating that at that time, we had the firefighters on one side of the city on the other side, and there was not a good compromise, and so we should have at least made sure that the plan was vetted for one purpose, either for the city and having that made it a qualified plan at that time. And having to come back and renegotiate this is an unfortunate.
Well, I'm not sure it's a lot of negotiating, for real, in my mind. Okay. I mean, with the exception of the education pieces coming out, so theoretically taking there's a benefit being lost, and I get that, and I agree with that statement. But some of the other stuff is technical corrections and stuff that's, in my mind, benign. But of course, I'm not a tax attorney, and I'm not trying to oversimplify anything as well. But it was new. Again, it went through court action about a year ago. The court said, okay, it is what it is, move forward. And back is against the wall and making sure it's a qualified plan or pay fines.
And it is important to do that. And you bring up a good point. I mean, it's not an easy conversation to have, and appreciate that you're willing to take this on and making it a qualified plan. So, thank you. That's all I have, Mr. Chairman.
Okay. Alderwoman Green, you have any questions?
Thank you, Alderwoman Spencer. You asked a lot of the questions I was going to ask. So I just want to get an understanding. We're not asking for a vote on this today. And so is, over the next week, are the different parties committed to continuing the conversation? And then by next week, we have more consensus, or where are we going from here, I guess?
We don't have a date or anything scheduled, but yeah, the commitment is, I'm committed to wanting to meet and try to negotiate or come up with the language. Like I said, we're not against the plan being qualified, okay? What the problem seemed to be is, under the disguise of qualification, there are some things being changed that negatively affect the firefighters. So we need to point those out, and if there's a different intent than what's on the paper, then let's change what's on the paper.
Right.
So, you know, we're willing to discuss and negotiate, but like I said, you can't just say, well, the intent is this, but it says something else. Like it says that board will have control to deny a pension. And it's just, we can't sign off on that.
Right.
That's just too vague.
Okay.
Okay? So, yeah, we're committed to having a conversation to straighten out the language so the plan can be qualified. Okay. But we don't want to take a big loss in benefits without something being either offered up against a quid pro quo, if you will, or, you know, we decided, okay, we need to cut because of money. But in this particular case, what Alderman Boyd brought up is that at the beginning fight, they were asking for cuts. This isn't supposed to be about cuts. This is supposed to be about being qualified and technical corrections. So if there's cuts in there, now you understand my misunderstanding.
Right.
Okay? So yeah, we're committed to meet, and we would like to get the language to the satisfaction of both parties in order to be qualified. That's not a problem.
Okay. That sounds good to me. And then when you come back in front of the committee, if it happens to be that you haven't reached consensus on everything in it, if perhaps you could supply us also with a couple-page document or a one-page document or something that we can kind of compare back to back of, what are the exact changes that you take issue with, so we can compare things side by side and make an informed decision.
Absolutely, we can make that happen.
Okay. Thank you.
It would be helpful if the comments that you made today, you put in writing to us.
Okay.
So we can have that. So, did that complete you,
Yes,
Alderwoman?
thank you.
I think, if you don't mind, Kara has one other thing.
Okay,
to add.
surely.
It's been stated that ERS had to pay a fine based on the determination letter application. From what I've been told, that was actually an audit, which is very different than a determination letter application. So I don't think that that's necessarily a fair comparison to be making, just so you know.
Can I ask her a question? So
Sure.
you've been told by who that that's not true? It's your understanding. But who told you that that's not true?
And she-
I mean, John Brewer of FRS.
And do we have any documentation to substantiate that? Because here's the
documentation.
There's a
I do have the
documentation.
documentation on it.
This
This is the closing agreement on final determination
Wait a minute.
covering specific matters.
What she was saying the audit was on ERS.
This was ERS, is what I'm saying. This
And
is
you're
closing
the plan-
agreement
you're
on
the plan
ERS.
administrator for
No,
ERS?
but I got this from ERS, and they gave me the closing agreement on the final determination covering specific matters, and it talks about, the IRS even threatened to tell ERS they might have to go back to January '84 to retroactively take away their qualification status back to 1984 if they did not make these changes. So this was on the closing agreement with the city, signed off on and certified by all the city people.
Yeah, I'd like a copy of it.
Okay.
Mr. Chairman, I think that's a very important point.
Mhm.
What do you think, Tim? Okay.
These voluntary changes or have the IRS come back, and I think it's an important distinction. No. Which side is correct here?
Well, she can provide us that. If she can provide us a copy of that letter.
It should have been provided. I didn't
Right.
realize it wasn't in the packet.
Okay.
But it will, we can.
We're done. Yeah, we're fine. Thank you. Alderman.
Thank you
Graham.
very much.
Thank you.
I
Thank
just want
you.
to make a comment about what Alderman French brought up and what, Al is saying about, giving authority to the board to make, technical correction. It makes us, what I'm hearing is the board can just change the plan at will. But I think the current language says, in order to be in compliance with IRS code. And that's clear. That I don't read that as if they decided to take away benefits, they can just take away benefits. What I read that as, if the IRS says you need to do this in order to stay in compliance, and it's more like an administrative task, then the authority is given. But I think if it makes the board feels better, it's not something that kills a plan. I would recommend taking it out if it makes people feel better. It's kind of benign, for real. It's not nefarious, it's not underhanded in any way. It's just minimizes some steps that the board would have to go through on something that may just be simple and minor with having a board bill. That was truly the intent. But if it concerns people because there's mistrust, unless it messes with the plan status, it could be taken out. Okay. Okay, so I want to just say that, because what I don't want to do is drag things out and make it a fight and pick at small things to say, well, what about this, what about this, what about this? I think what Mary Beth has done is been very clear at the steps. She is a renowned tax attorney. She didn't just start this last year or so. She is well respected across the country. And if we hire people to get their advice on how to move forward and they say take it out or put it in, I think it'd be prudent for you or us, if we're paying that person for that advice and they have a lot of credibility and integrity, that we might want to do that. I don't think it's, and it's just my opinion, that it's responsible to throw a lot of stuff in a plan and see what sticks and send it to the IRS to see what sticks. Because there are people who are paid good money and have a lot of experience to tell you, this is not going to stick, this is not going to stick, so why do it? You know, I don't think that's good policy to operate in that way. And this has been a challenging experience for me to even want to carry the bill. But if you know me, and if you really know me, I like to do what's right, and I like to do what's fair, and I'm always looking for a win-win. Now, I can't pronounce your name for me. Croswick? Yeah. Croswick, okay. So she did send a letter on February the 2nd about some of the same concerns that she presented to you. And Mary Beth from Ice Miller responded with some of those concerns, to those concerns, and it's nothing that can't be fixed. Okay? It's nothing that there's a real struggle of disagreement with. There's a different opinion on some things, but what we can come together on will be in the committee substitute, next week. I think the only thing that's going to be a sticking point is the tuition benefit. And it's my understanding that it's just not going to work in the bill in order to make it a qualified plan. Now, it's my recommendation that since this is collective bargaining time, that it's a good time to talk about it, to see what the city can do, to offset this outside the pension plan, since the pension plan cannot pay that particular benefit. So I appreciate, your time today, your willingness to sit through, and listen to all of this. I know it's challenging. Again, nobody wants to be the bad guy or lady, and it's not about that. There's no conspiracy here. It's nothing underhanded. There's no political paybacks. It's about good policy. And that's what I'm interested in. So you will receive a copy of the letter from Greensfelder and Ice Miller, that addressed those concerns and overcame some of the objections. There will be a substitute to, again, clarify some things. But, Mr. Chairman, I'll speak and yield to you about that piece. If it's a sticking point as far as the administrative task, giving the board that, rather than bringing a board bill, it can just be taken out. I'd rather do it now than to.
Right. We'll speak on it.
Okay. So.
But there will be some dialogue between now.
Oh, absolutely. Absolutely. Okay. But we can't do this stand your ground stuff. I do plan to be back here on Thursday and ask that you vote a board bill out.
Mm-hmm. Okay.
Okay.
All right, then.
Thank you.
Then I believe that completes us. Thank you. Thank you for your patience in waiting today. That completes our agenda. Therefore, our meeting is adjourned. Thank you.